ಸುಳ್ಳು ಕೇಳ್ತಾ ಇದ್ರು ನಾನು ಮಾತಾಡಲ್ಲ. ಟೆನ್ಷನ್ ಆಗ್ಬೇಕು ನಮ್ಮ Pero por tanto, fue tu gato, ¿no? Tú,
Oh,
yes, urgency, my lord. We have it tomorrow. For this reason, my lord, my election has been set aside by the KT as well as by the.
What is set aside?
Election, I am a director.
Election.
Yes, my lord. My lord, now for the vacant post, my lord, the date is fixed for the co-option. Therefore, some urgency, my lord.
Which date is fixed?
14th. They have fixed the date on 14th.
14th,
14th.
day after tomorrow.
Please.
My lord, PIL, my lord, and there's an urgency is that there has been a construction on a stormwater drain. The construction is continuing. Therefore, there is an urgency in the matter. That
All
not been-
circulations subject to removal of office.
They're not permitting me to comply with the office objections also. That is why they have I have to move a memo, my lord, if I may be permitted.
It can wait. No,
The
it
only
can
thing is that the
within 10 days.
construction.
Within 10 days.
Great.
well, there is an urgency, my lord. In this recent case, the trial court has issued warrant for execution of attachment of movable and immovable properties. If it can be kindly heard tomorrow.
Within a week.
My lord, medical education admission matter, my lord, the results of the petition are.
One by one. Yes.
My lord, the respondent employee, my lord, is retained from survey. His terminal benefits, my lord, have not been released, my lord, for the pendency of the appeal.
You remove the office officers, it will be listed within 5 days.
My lord, already listed before the.
Then it will be listed. No need to,
Taken up for.
no need to no need to make a mention or submit a.
Date was not given on the last occasion.
See that it is listed. It listed within 15 days. Yes.
So it's a contempt petition. The honorable single judge is directed respondent to consider my refund application, grant the refund within period of 4 weeks.
It can wait. It will be listed.
But it's a huge demand.
Once you remove the objection, it will list it.
It's been cleared, my lord. Date is
Then
not,
it will, no need to mention.
date has not been,
It will be listed.
My lord. Medical education admission matter, my lord, the result of the student is not yet announced, my lord.
Pardon?
The results of the student is not yet announced, my lord. There is urgency in this matter, my lord. Kindly have the matter tomorrow.
Mention, it will be listed once you remove the office objection.
Office objections are already.
Then wait for 5-6 days.
My lord, it is pending matter, my lord. By virtue of interim order of this honorable court, my lord, the student was permitted to take the first MBBS examination, my lord. The results of the petitioner is yet to be announced.
Wait for 5-6 days. Honorable Chief Justice say, wait for 5-6 days. It will come.
Please, my lord.
Yes,
Serial number 20, my lord. I filed a memo for withdrawal. I may be permitted to withdraw the
20.
complaint.
Yes, is there.
Please wait.
Just wait, Mr. Allow 20.
Put up, sir. Put up, sir.
Learned advocate, Mr. So and so, invites attention of the court
20.
that he has filed 20.
20.
20. Learned advocate, Mr. Giri Kumar,
Yes.
stated that he has filed memo for withdrawal upon instructions of the complainant. The memo reads as under, give the memo. Any of the request, the permission to withdraw the contempt proceedings is granted. Dismissed as withdrawal.
Great. Great.
Yes.
My lord, serial number 66, if I may seek for an adjournment.
56.
66, my lord.
66.
I'm
What
for the
is it?
petitioner. If I may seek for an adjournment, the arguing counsel is unwell today.
All at 2 weeks.
My lord, it may be taken sometime next week, my lord, anytime next week.
What is it about?
My lord, it's a mining matter, my lord.
Mining, man, you can wait 2 weeks. Yes.
Serial number 73, my lord. I'm
70.
appearing for respond number 3 and 4. Lord, seek for 2 days accommodation, my lord. The council, my lord, is not keeping well.
73. It is of 2018.
2 days time, my lord. I was seeking for only 2 days time, my lord, because the council on record, my lord, is not keeping well.
Fourteenth.
Please, my lord.
14.
Grateful, my lord.
Serial number
Serial number,
Yes.
serial number 74, my lord.
I appear for the same date, my lord.
Grateful, my lord.
Before I am for the petitioner.
I'm appearing for respondents 3 to 52, my lord. In this case, petitioner has filed rejoinder, my lord, and they have not served.
Which matter? Serial number
Serial number 74, my lord.
74.
I request for accommodation.
It's
my lord.
also a very old matter, old of it.
Please, my lord, they have served the rejoinder to our objections, my lord. They have not served the annexures along with the rejoinder, my lord. To seek instructions with you.
I am for the petitioner in this case, Lord. I'll serve the
Sure.
copies to him today. Maybe 2 days they are time.
You are for the petition. You are for the petition.
Respondent
Respondent,
2 to 53.
Raghuram.
I am for the petitioner.
Sandeep.
Learned advocate, Mr. K.S. Raghuram, for the respondent, stated that since he has
Sandeep
received
Patil.
rejoinder, he seeks time. Stand over to next week, 18th,
Please.
18th.
Serial number 71, my lord.
Serial number
71, my lord.
71.
Requesting to adjourn the matter, my lord. Requesting to adjourn the matter, my lord.
Why?
I appear, senior is not in station, my lord. There's a contempt related to it.
21st.
Please, oblige me.
Lordship, kind permission. Serial number 62.
62.
Please, I appear for the appellant. The connected appeal is ordered to be listed on 15th of this month, my lord. May this appeal may also be called on 15/3, my lord.
Serial number
62,
62.
please.
306.
62, my lord.
306.
Please, my lord. There is another connected appeal 319 of 2024, ordered to be listed on 15th of this month, my lord. May this appeal may also be listed on the same day.
As stated by learned advocate for the appellant. The cognate writ appeal number
319 of
to
2024.
be listed on 15. In that view, both the writ appeals to be listed together on 15.
15.
Number 1, Mr. Radhakrishna.
My lord, I am for the petitioner, my lord.
Yes.
My lord, petitioner is a law student in the Vidyavardhaka College, Law College, Mysore. During 2019 and 20, he did his first year and got admission to second year in 2020-21. 2021 is an year of COVID era. Total, the whole year was, there was an outbreak of this national disaster, COVID. And he was also suffered COVID during the examination notification was there. My lord,
So we are issuing notice. But in the meantime, you remove the office objections.
my lord, I attended the objection. This is a new objection. The 3
no
days
objection.
back, phoned up. I will
One office
remove it.
objection. All right.
And I have not received the.
Notice.
My lord, I have not received
The
any
notice is-
annexures from the respondent.
Lord Learned, your senior counsel?
No.
Lord Learned Counsel, Mr. So and so, or the appellant, notice returnable. on. Three weeks. You are accepting the notice? Learned additional government paid, government advocate, accepts notice.
Respond number 3. Still number 2. SR Dodpat.
Serial number 2, I am appearing for the appellant. My lord,
Will it
matter has-
survive?
my lord, it's become infructuous. I will
Learned
pay the
advocate
court
Mr.
fee and
So-and-so
lordship may
said this
kindly
will-
permit me
It was
to
being infructuous, accordingly disposed of as not surviving.
not survive.
Still number 3.
Still number 3, I appear for the petitioners, my lords.
Second set,
This is
Second
a
set
writ
is-
for mandate. Pardon, my lord.
this is PIL.
Please, my lords.
Second set is supplied.
My lords, if I may make a submission on this, there are 11 petitioners in this matter, my lords. Rather than complying with it, I've, my lord, preferred a fresh PIL, which I have filed on Friday because, my lords, the declaration affidavits I was not able to obtain for all 11 petitioners in time.
This you are not pressing.
My lords, the difficulty is this is posted before this bench on the basis of an order by the learned single judge. If the court believes, my lord, that it is not a PIL, my writ may still survive. What I'm requesting, my lords, is that the matter be passed over. I may be permitted to move a memo to list my fresh PIL, my lords. I'd file it on Friday. If may be taken up at 2:30 because I'm
Why
seeking
this should
urgent.
No, why this should be kept pending?
My lords, the PIL has been posted before this court on the basis that there is a public interest being espoused.
Madam, you
However,
have filed a fresh PIL.
please, my lords.
You pursue that on merits.
My lords, the difficulty is I filed it on Friday. What I'm seeking is to be permitted to move the matter for 2:30 this afternoon.
That is a different thing, but this will not survive.
Please, my lords.
Learned advocate Mrs. So-and-so
I request that
states
they be
that
listed at 2:30, my lords.
yes, the very applicant, very petitioner has filed this petition
Please, my lord.
in
I've
the-
already filed it
the
on
nature
Friday.
of
My
public
request to
interest
be listed at
litigation
2:30.
in relation to same subject matter. In that view, with liberty to pursue the said freshly filed petition on merits, this petition is
Please.
not entertained.
May I request the matter may be taken up at 2:30, my lords. I'm not moving for urgent interim relief, my lords. The issue is,
In PIL, there is nothing like 2:30.
my lords, may I request the end of the list, my lords, because the issue is there's the railway underbridge which is being closed off, my
It
lords.
is not possible. When it is come, we'll deal with it.
Please, my lords, may I request tomorrow, my lords.
Wait for.
Number 4.
Lord, in this
Second
matter,
time
we
is
have
objection.
complied the order.
For the complainant.
The direction is not to change the revenue entries. We are not changing it. We have filed.
Full done, my lordship. Court fee already paid. my lord.
Done, withdrawing.
Full done, my lordship. Court
Withdrawing?
fee already done, paid, my lordship.
No, are you withdrawing this?
Contempt.
Or is,
Contempt, no, my lordship.
so it complied with,
I have already paid, my lordship.
It's all right. It says we have not made.
learned government bidder Mrs. S.S. Mahendra stated that the order under contempt is complied with.
Compliance affidavit is also filed. Compliance affidavit is also filed. It's on record.
Plain,
Affidavit.
compliance affidavit is also filed,
It's also.
which is on record. In that view, this proceeding does not survive and it stands closed.
Number 5. To
In
go
this
with
matter also, my lord, we have complied the order.
You have complied with the order.
Yes,
What was the direction?
to pay gratuity and not,
You have paid it already.
yes,
When did you pay?
on 26/2/2024.
Complied.
Lord, I have
Not complied.
no, I have no instance.
It's all right. Now he is saying, nah, there is no reason to doubt the version of the government council.
Following was the operative portion in the order dated 25th September 23 of learned single judge, which is brought under the contempt jurisdiction of this court. Then court the directions at page 25.
Compliance affidavit is also.
When the contempt application comes up for consideration, learned government advocate Mr. S.S. stated that the order is complete, the directions are complied with, and the payment
5,25,777.
of 5,21,000
25,777.
525,777 towards gratuity.
Yes, my lord. Gratuity and interest.
Towards gratuity has been paid to the complainant. Full stop. in view of the statement made by learned government advocate, the contempt no more survives.
Compliance affidavit is also.
You have some
filed.
reservation?
Yes, my lord.
What? He's saying responsibly.
No, my lord, what they say is,
In case of difficulty, permission to revive the proceedings or his liberty is reserved for revival of. In case of the.
Number 6.
I appear on behalf of the
In this matter
complainant.
also, Lord, we have complied the order.
My lords, I have received the compliance affidavit recently. I'll go through it and make my submissions. It may kindly be taken up next week, my lord.
Direction is to consider their claim, Lord.
It
We
is
have
considered.
considered and issued endorsement dated 2/2/2024 as per annexure R1, page number 9.
But senior is
The contempt is between court and the alleged contempt, nothing beyond that.
My lords, kindly pass over, my lords. Senior would like to make some submissions.
While disposing of the writ petition on 17th February 2023, learned single judge directed Dispensary Tehsildar, Bangalore East Taluk to consider the representation given by the petitioner, to further direct to verify the original record of the petitioner and pass necessary orders to enter the name of the petitioner in the land revenue records expeditiously and within stipulated time. Full stop. It was the aforesaid directions which were complained of for their non-compliance by invoking the contempt jurisdiction of this court. Paragraph. On behalf of the respondent, compliance affidavit is filed. Compliance affidavit dated 4th March 23 is filed, along with which endorsement dated 2/2/24 is produced, which show that the necessary decision is taken and the directions are complied with. Full stop. In paragraph, in the aforesaid view, nothing further is required
My
to
lords,
be done
one indulgence.
in the contempt proceedings. If the complainant is dissatisfied with the order, liberty is reserved to challenge the same by independent appropriate proceedings, in respect of which this court does not express any opinion on merits.
My lords,
Present.
it may kindly be kept pending, my lords. I
No.
just seek for a week's accommodation to make my submissions on.
You know, this is contempt jurisdiction.
Please.
Once
I
it is
understand.
complied with, we don't have any further to say.
Number 7, to Javed is.
here is for the complainant, my lords. There is no objection in respect of the translation copy, my lords, and each page signature, my lords. Only 2 weeks time can be granted, my lords, I will comply the objection. There is the interpreter. See, my lord, they have.
Where is the directions?
Page number?
Page number 9, my lords, interim order, my lords. Writ petition is pending, my lords.
Petition is pending.
Please, my lords.
Against the interim order you are here.
Please, my lords.
Which is that order?
Page number 9, my lords. Since interim order has been granted in WP number so and so, there shall be an interim order in petition also in the same.
In all such matters,
Interim orders, we don't entertain.
we don't entertain, but it's covered by judgment. You have to
Please.
complain to the same judge.
Please, my lords.
So we're drawing or we dismiss?
I will withdraw, my lords.
Learned
Quickly.
advocate sponsor
Yeah,
seeks
but please.
permission to withdraw the present proceedings in order to approach,
Same.
in order to agitate his rights where the main proceedings or writ petition is pending. Dismissed accordingly.
Please, oblige.
Number 8.
I'm for the complaint in this case, my lordship. I'm for the complainant. Kindly prepare time, my lords, 1 week. Complaints the office objection.
Order,
Kindly prepare time, my lords, 1 week.
time.
Yes, my lords.
Let us,
Complaints the office objection.
what
my
are
lords.
the directions? We'll grant time if necessary.
It's against the interim order.
This is also interim order.
Interim.
Yes, my lords.
Interim order.
Yes.
Violation is, the final order is there, no? That serves Honorable Justice Sunil Dutt's order, na? At page 32,
Yes, my lord.
Sir, Mahendra, it is
37, my
not
lord.
interim order.
final order.
It is
should
not
note it.
interim order. Writ petitions are allowed in part, page 36. Petition is disposed of.
My apologies. Yes, yes. 22250. I was under the impression. Next year, see, I was seeing.
What do you want?
The first time, Lord.
Notice. Returnable after 3 weeks. Learned government advocate Mr. Mahendra accepts the notice.
For R1.
Within which time the applicant complainant shall comply with the office of justice.
Much better, my lord.
I accept notice for R1.
Expected that before the returnable date, the directions shall be complied.
I should.
So 19th April,
Much better.
still number 9.
Any other party, private party?
No.
For the appellant,
Accused number 2 is the Tahsildar.
and I pray for 3 weeks time, my lord.
Serial
Nine.
number?
9, my lord.
9.
Writ appeal.
3 weeks. Do it. 3 weeks time is granted to comply with the office of justice.
22.
To be listed thereafter.
Still number 10 for third time.
My lord, 2 weeks time may be granted. I will comply all of the office objections.
This is
Because
third time.
Annexure C and D,
3 times.
typed copies are required.
You are
That
Vishnu Kumar.
Yes,
3 weeks time.
2 weeks time.
2 weeks time.
2 weeks.
Last time.
Ah, please.
2 weeks time is granted to learned advocate to comply with the office of justice. Failing which the writ appeal shall stand dismissed without reference. Failing which the writ appeal shall stand dismissed without reference to or order of the court.
In spite of that, they file office objections, then I have to.
You want 2 weeks, we are granting 2 weeks. If not complied, automatically it will get dismissed.
Peremptory order.
One submission, please.
No question. Again, please call next matter. We cannot go on
Number
wasting time
11.
like that. It's a hot court.
Even
Still number
after
11.
complying office
Raghavendra
objection.
C.
If
Do it,
there-
do it.
Not waste time that way.
Still number 11.
Serial number 11, we have complied.
Also interim order.
Complaint. Complaints affidavit was filed on 6/3/2024.
It is what is happening.
Again, interim order.
Interim
Your
order,
Honor.
but we have complied.
Complied.
I can-
But is after the interim order, Your Honor, there is an RTC was changed, Your Honor.
Learned government pleader, government advocate, Mr. S.S. Mahendra stated that the order dated 6th February 23 passed by learned single in writ petition number 896 of 2023 is complied with. Full stop. Learned advocate, Mr. So and so is unable to dispute the statement. Accordingly, the contempt proceedings no more survive and are closed. And they are closed.
For 4 times, still number 12.
Hence affidavit is filed, which is taken note before that.
The appellant in this case, my lords, pray
Bindu.
for a week's time, my lords, to complete the office.
Which one? 11?
12th.
12. So what happened to 11? Disposed.
11 is disposed of.
So for the 4th time, madam,
12, 4 time.
Pray for a week's time, my lords. Pray for a week's time to complete with the office of justice.
we are granting 2 week time, but failing which it will be automatically dismissed.
Please.
2 weeks time is granted to the applicant to remove the office objections. Failing which the writ appeal shall stand automatically dismissed without reference to or order of the court.
Right.
For 6 times, still number 13.
For the appellant, translation copies has to furnish, so 3 weeks time may be granted.
3 weeks time is granted to supply the translation copies and to remove any other objections which are required to be removed.
Great.
Number 14
If I am fast, please tell me.
time.
Appear for
If I
petitioner.
am fast,
Press
please
per
tell
week.
me.
Number 14.
Serial number 14, appear for petitioner in this case.
Which one?
Press for week time, my lord.
14.
14.
This will belong to our
Proposed to PI. PI violation. Very important, small,
3 weeks.
Insignificant. Yes, my lord.
Same order, 3 weeks, time is granted to remove you, failing which petition shall stand, the writ petition shall stand dismissed without reference to or order.
For order still number 15. So MV Charity.
Hearing for the state, my lord.
Respondent number 2. One mail. Lord,
Regular board starts. Yes, Mr.
in I appear for the appellant in this matter, my lord, I was required to find out the death of the respondent number 4, Jayamma, my lord, Muniappa. In this regard, my lord, an inquiry has been held by the special task force of the Bangalore Development Authority. And my lord, now after my lord verification, it is found that my lord, Jayamma died in the year 2003 itself.
My lords, one submission, my lords. On the previous occasion, there was a direction to file affidavit, my lords, about the status of respondent number 5. My lords, respondent number 2 is filing the affidavit, my lords. There was an order. Yes, my lord.
There was an order, my lord. Kindly take 11/12/2023. Lord, on 11/12/2023, my lord.
Let's take the status of and to secure a report from the consent of. Yes, filing. Have you served a copy on the other side?
Yes, my lords.
Yes, served a copy also.
Yes, where is the report?
No, that.
File.
Have you seen the report now?
No, I have.
Served on you.
Yes, I have the report of the special task force of the Bangalore Development Authority, who says that, my lord, on 17/6/2003, my lord, the respondent had died.
Similar matters, what you have done?
Your lordships have already admitted and issued notice to some of the matters in which, my lord, and there's an order of status quo also here.
Where the state goes, what is that? Okay. You have to- but we can- Okay. The scheme lapses. Question, what happens to the petition? Who? Lapses which do. Land will cure. Other leaders, land will cure. So we have to make it simple. Okay. So. Which is that identical matter?
Lord, your lordships may, I'll pass on the number of the particular.
You had
case.
argued that.
Yes,
19970? No. This is the identical matter.
Lord, I'll give the number, my lord, of the particular number of the writ appeal.
Give the
Similar,
number.
please.
Is to be admitted. Appeal, heard so and so, so and so, so and so, so and so, the respondent, appeal is admitted.
Sought for interim prayer.
To be,
Interim order you
There's
sought?
already an order of status quo, my lord, in this matter.
to be listed with Give the number.
Please, actually.
Order of status quo granted earlier shall continue to operate till the final disposal of the order.
Please. Oh, please.
The appeals may be listed for final hearing after 2 months.
With your lordship's kind leave, my lord. My one application for impleading is pending in this matter.
Yes.
There are some office objections which are raised, my lords. Your lordship may kindly grant me a week's time to comply with the office objections.
With regard to that office, application for impleading which is filed, Lord, they have not still served us a copy to say that as what is their right over the property, Lord, that's not been served on the appellant. Lord, may direct my.
You are referring to serial number 15?
Yes.
Please, my lord, serial number 15.
You serve copy, Mr. Counsel.
My lords, so if I am not wrong, my lords, I have already served a copy on 5/10.
Please serve one more copy.
Again.
One more
I
copy.
shall, my lords, I shall. Please.
So learned counsel, you are Mr. Murugesh.
No.
Respond to serve the copy of the impleadment application to the learned advocate for the writ appellant.
I shall file my objection.
To be listed after 2 weeks. Within which time the office objections, pending office objections shall also be complied with.
Grateful, Lord.
Please.
So I appear for the petitioner, my lord. This petition, my lord, is in respect of the industries that are on the coastal, which is on the CRZ zone. And in respect of the pollution that is being caused by them, my lord, they have fish processing units. In respect of whether at all they could be on this coastal regulation zone, my lord, this honorable court had directed the District Coastal Zone Management Authority to look into the issue. The District Coastal Zone Management Authority, my lord, had looked into the issue and has found that there are violations and has recommended that steps be taken by the state level monitoring committee, my lord. This honorable court, by order dated 29th September 2021, my lord, had passed an order directing the state level monitoring committee to look into the same and pass orders on the same. However, my lord, the state level monitoring committee has so far not done anything. In the meanwhile, my lord, there was a lot of pollution that was happening. Since there was a lot of pollution happening, my lord, this court had also directed the Pollution Control Board to conduct various inspections. The latest inspection report that has been produced before this honorable court, my lord, in fact shows that there is a high level of pollution and it is in fact non-conforming. So there are two aspects, my lord.
The inspection report is of the dated 5/2/2022, my lord.
By the district level committee.
No, my lord, the pollution control.
Pollution control.
Yes.
My lord, that, is that produced? My lord, that is not produced. My lord may grant me 2 weeks' time, my lord. I'll produce that report along with the action, my lord, if any that has been taken, I'll place.
So
it
you are
before-
referring to the report of the district level committee?
Yes, 5/1/2023 is the order.
My lord, the district committee report has been produced, my lord.
Karnataka State Coastal
It
Zone
is filed already,
Management
report is
Authority.
My
filed.
lord, the district committee report, my lord, has been filed.
When?
In 21 itself, my lord. It has been filed. And in fact, on the basis of that, my lord, had directed on 29th September 2021, this honorable court's order, which directs the state level monitoring committee to take action on the basis of the district level, district coastal zone agency's order. Please, my lord. On 29th, this court has passed an order, my lord.
29 September.
Yes, please, my lord. 29 September 2021. If my lord says, Learned Counsel for Respondent number 1, Union of India has informed this court that the state level monitoring committee has to take a decision based upon the report submitted by the District Coastal Zone Management Authority, and the same has not been done. The state level monitoring committee is directed to take appropriate decision in respect of the report submitted by the District Coastal Zone Management Authority in accordance with law within a period of 4 weeks from today.
No, that was the report filed by District Coastal Zonal Management Authority.
Yes, please, my lord.
That's not the report filed by the district, same authority.
No.
State committee report.
State committee report is not filed, my lord.
Not filed.
Please, my lord. State
Correct.
committee report is
I'll
not
file
filed.
the Karnataka State Coastal Zone Management Authority's, my lord, report. My lord, with regard to whether any action has been initiated My lord, I will seek instructions and make my submission. My lord may have this after 2 weeks.
My lord, as
But it is not the district level committee. No.
No,
So where is the report of the district level committee?
my lord, that I have to seek.
District level committee report is not filed.
My lord, it is filed.
No, that is district state level monitoring committee.
Yes, my
Is
lord.
it the same committee?
Please, my lord, under the CRZ notification, the District Coastal Zone Management Authority is to look into this. In fact, it looked into this on the basis of the order of this
This is
court.
not correct. Go to order date 11/6/21.
Please, my
The
lord.
district level committee is constituted on 19th February.
Yes, please, my lord.
Same.
Yes, my lord. That has been filed, my lord.
Report and action taken, both they have to file.
So learned
The government has to. Additional.
additional government advocate.
Lord, one small submission. my lord.
Nilofer,
Yes, my lord.
fixed time to
Yes,
file the district
yes.
level committee report as well as the action taken report. How much?
2 weeks time.
2 weeks time is granted to her to be listed on
Obliged.
26th of March.
Yes, my lord.
My lord, may I make one submission, my lord? Now, even now the pollution is continuing, my lord. What is happening is that this is a fish processing unit. The air emissions that are coming out, they're extremely toxic, my lord. And the petitioners are all residents of nearby regions. My only request would be this, my lord. The Pollution Control Board also had been directed to look into this and look at the pollution that is being caused. The previous, the report that has been filed by them was in 2022. In 2022, my lord, they found in fact that the norms are not being complied with.
But this report will be comprehensive later, so.
Please, my lord, it may also look into this aspect. Please, my lord.
That report needs to be seen, my lord. There, I've not been served a copy of it. sir.
Which report?
SPCB, sir.
Committee report.
We'll serve the copy on that.
How,
But one
So all
small
the-
submission
all
on
the
the
fact-
report itself, my lord.
how copy of the report?
So if they may
For you
also,
file, you have to serve to all the sides.
Indeed, we'll do the read.
if they may also be directed to look into the aspects of pollution, my lord, because
Let us have the report, then if,
Please.
then in Lacuna will
This is the report.
consider it at that time.
Give it to me now. I will give it to you. Let them not be confusion because I'll get it in. Obliged.
I appear for petition in this case, my lord. My lord, on 10/1/2024, this honorable court has directed the deputy commissioner, my lord. This honorable court on 10/1/2024, my lord, directed the deputy commissioner with the assistant of ADLR, DDLR. Inspect the spot and submit the report, my lord.
Report is filed or not?
My lord, it's filed on 4th of March, 2024.
Where is that page?
4th of March you have filed.
Yes, my
Of
lord, we
March.
filed it in the office.
But they have not done it properly, my lord.
Let us see.
Not all. Photo of, this is, yes, it is there. Fourth of March.
February. What the report says? AGA,
I'm
what the
sorry.
report says?
My lord, the report says that the property totally measures 15,800 square feet.
Ah.
And the temple is an occupation of 15,234 square feet. My lord gets it in a spot inspection report. My lord, page 11 of the report. The photographs are also produced.
The very Same sketch prepared by the BBMP, the.
Now, question is whether there is encroachment of public property, road or
Is
not.
not shown.
What you have said in the report.
That is not shown.
Lord, that is not said. They said that as per the village map,
Serial number 2, my lord. ರಾಮಠಾಣ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಭೂ ದಾಖಲೆಗಳ ಇಲಾಖೆಯಲ್ಲಿ ನಿರ್ವಹಣೆಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಸ್ಥಳದಲ್ಲಿ ದೊರೆತ ಮಾಹಿತಿಯಂತೆ ಅಳತೆ ನಿರ್ವಹಿಸಿದೆ. Only on the basis of the spot, my lord, they have measured the property and given the report.
No, whether there is, so simple we had asked for
yeah.
in our order. Whether there is encroachment or not. The answer should be binary, yes or no.
Yeah.
If yes, what is the extent of encroachment? Where is that?
Lord, that is not in paragraph 11, my lord, the third, in page 11, paragraph 3. As per the original village map, there are no records about a road in this spot.
So evasively it is crafted. We will not know, even if Ren and Martin come, they will not be able to know what you have said in the report. We have asked in our order, kindly see our order,
My lord,
whether temple people have encroached the public road or not.
my lord, can I seek for some time, my lord, so that I can file a better affidavit?
We
with
don't want
regard-
affidavit, we want a report.
Very well, I'll see that the report is filed, complying with the earlier order of my lords dated 9/2/2024.
So without clear report, how will be able to file clear affidavit?
My lord, I'll see that they inspect again, a notice is issued, I'll redo the entire exercise.
Brother is rightly saying yes.
Lord, I apologize, my lord.
If you can understand report, please explain to file it better report. On perusal of the so-called report filed by the respondent on 3rd March 2024. Could be gathered that it clearly lacks clarity and is not satisfactory and does not satisfactorily opine about the encroachment committed by the temple authorities. Full stop. At this stage, learned additional government advocate, time to file further report on the basis of the facts already collected. Full stop.
My lord, can I redo this exercise, my lord, with notice to the other?
It will be open for the authorities to undertake the press exercise.
Obligement.
If said, if they are so willing. After giving notice to the.
Yes, yes.
With all necessary documents, my lord, without pursuing any documents.
Now the report has to come now.
Yes.
4 weeks,
Very well.
4 weeks. 4 weeks is time is granted, put up after 4 weeks.
Appear for the applicant's counsel.
Appear for the respondents in the application for impleading, my lord.
I think for state, 2 to 5 months.
The application for impleading, my lord said, you should notice, my lord, last time, and they were to be impleaded to this proceeding. My reference said no objection not to the impleadment application, then.
I have no objection for impleading, my lords, but I request them to furnish a copy of the amended petition so that I can submit, make my submissions.
Who are you?
They are the persons to whom the compensation had been paid.
But they want to implead me as a respondent, my lords. I was not a party in the writ petition.
Who are they?
They are the persons to whom compensation had been paid. And
Already paid.
had been paid.
Which ought to have been paid to your client?
Which, oh, no, I am not the KIADB.
KID.
So KIADB, my lord, there was a civil proceeding going on. In the civil proceeding, my lord, one party was held to be the owner of the property and therefore compensation was paid to them. Subsequently, a regular first appeal was filed. And in the regular first appeal, my lord, it was held that they are the owners. Then, my lord, a writ petition came to be filed, albeit for change of name or in the mutation records. But subsequently, it was amended to say direct the KIADB to pay compensation to us. But, my lord, the persons to whom compensation had been paid had not been made parties, and the learned single judge passed a direction to us to pay compensation to them. Again. Therefore, my lord, we made a request to this court, my lord, that they may be made parties, because whatever orders pass.
You are paid compensation pursuant to some civil court order?
No. There was a declaration of title, my lord, in his favor. Therefore, he claimed that he's entitled to compensation.
No, they sue for declaration to indicate they are declaring. But you see, the declaration of whatever you do to them, to whom you have paid is not, you might payment to this. It's the order in appeal. The order is also stayed, perhaps not stayed.
No. Lordships had directed us to deposit a sum of 25 lakhs, which we did. 20 lakhs.
They are the persons to whom you have made the payment.
Yes.
So you filed the application.
Well, they'll have to be impleaded now, my lord. We, of course, they were not parties. Therefore, we impleaded them as parties to the.
You are for?
I am for the KIADB, the appellants.
Where is your IA? 3 of 23?
1 of 23.
IA 1 of 23.
3 of 20.
1 of 20.
1.
1.
1 of.
IA 1.
1 of 23.
And 3 of 22.
And 3 of 20.
Yes. They proposed to implead my husband and father. He died during.
One is for bringing the legal aids.
Yes.
Please.
Yes.
Proposed respondent died, my lords.
There was one respondent, lord, we were supposed to implead, but he passed away. So the legal representatives of the proposed respondent.
You may in the recess, I'll dictate. This is granted. But IA number 1 of 22, the present application is filed by the appellant seeking to implead the heirs and legal representatives of. This is respondent number. Who has died?
Respondent number 3, proposed respondent.
No, proposed respondents.
Proposed respondent.
Proposed respondents.
He was
Seeking to
proposed,
implead
but by the time the.
Proposed respondents, number 2, 3 and 4. 2, 3 and 4.
6 and 7.
Proposed respondents who are named in the course title. Of
6,
the
7,
application. Full stop. For the ground stated in the application, supported by the affidavit, the prayer for impleadment of the said proposed respondents deserves to be granted. Accordingly, the IA is allowed. Yes, the amendment to the course title shall be carried out by the.
We'll do that.
And they may
Within 10
direct to
days.
furnish copy of the repeal memorandum.
Furnish copy to them.
We'll serve a copy.
Great.
Very good.
I'm filing on memo, sir.
ಮೆಮೊ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. Read paragraph 7 of the memo.
I want to make some detailed submission before this court in the above case. Hence appoint one interpreter come translator to make submission in the above case. Even by permitting me to make written submission also.
You
Hence
are an
this-
advocate.
Yes,
Did you write your law examination in Kannada or English?
Kannada.
In Kannada. And how you have filed statement of objections, written statement in the court below? We'll call them.
Written statement?
Written statements. You have filed any written statement,
No,
plain?
no.
You are not a practicing advocate.
I am practicing advocate, seniors file my ಮಾಡ್ಕೊಡ್ತಾರಲ್ಲ, I just only take it and submit. I don't draft any on my own. Anything on my own.
My lord, I'm sorry to make this submission. 2 weeks back, my learned friend was arguing vociferously before my lords in one matter, where he had filed a memo in English, not in Kannada. And he says he's a junior, he's a trial court junior advocate. Point number 6.
Please read 6 also.
I am trial court junior advocate. I am very poor in law as well as in English. I can submit only in Kannada as my mother tongue is Kannada.
Who has drafted this memo?
My friend.
You have filed it, no? You have not said your friend has drafted it.
ಬರಿಬೇಕಾ?
We are not here to advise you. We are asking a question. You are bound to answer. You are an accused. Don't take liberty. You are an accused.
ಅಲ್ಲ ಅದು ಬರಿಬೇಕಂದ್ರೆ
I don't say those words here. You are an accused. Stand properly first.
Just below his signature.
Except that the friend has to be fairly English.
Mr. Party in person.
Yes, sir.
We'll provide you a legal aid advocate to assist you in your case. You want it or don't?
I need, sir, I need legal aid.
Then you will no more be. So you give a memo in writing that I am willing to be assisted by a legal advocate from the penal advocate who may be appointed by the legal aid committee.
Sir, already application is pending, sir.
No. Application we are granting it, but you give in writing so that we can properly undertake the procedure to provide you the legal aid.
Already my application is there, sir. In
Give
file.
one more copy.
One more.
We're asking you to give a memo. We are granting that relief now.
We don't want anything more so that we can undertake the procedure to require the secretary of the legal aid committee to provide you an legal assistance.
I don't want legal aid from.
Yes, you said you want.
I legal aid from committee. I want legal aid from court because one application pending since 2010.
They all are competent advocate. Will be able to put up your case.
Application number 52/2010 pending since 2010.
We do not know all that. This is of 2023 content matter. What all happened when Alexander had come here, we don't know. This is 2023 contempt petition. In this, have you found any application? Now you have answered Honorable Chief Justice that you want legal aid. When Honorable Chief Justice suggested, you said yes.
Yes.
And now you want to reside.
Sorry, I already filed application, sir. Application is there in file.
These proceedings?
Yes, in this proceeding, cost title is also reflecting, sir. In cost title also is reflecting that I filed application for legal aid and.
So we are saying in light of what you have submitted today. You want interpreter and you are a junior advocate. So we are providing you the competent legal advocate to assist.
Yes, sir, I need legal aid, but appoint one pro bono advocate through court, sir.
Yes, that is what we are.
Yes, sir, not from my committee. They have cheated me. On 100 application is pending there. Please call for report, sir, regarding my pending application.
No, we can't do that. There's a committee and chief, if somebody comes, please help. Nobody. No.
in the registry, that application is in file, sir.
We are not going to act in any manner unless you submit in writing, whatever you want to submit.
Sir, my application is there in already
So you
filed.
said you are saying that you have not submitted anything.
I have not submitted before AG. I have served copy, that's it. I filed copy.
So you place this on record of the court formally, so that we can act upon your request. We don't want anything. Our record must be clear, Mr. Party in person.
The persons we need not that, with that leniency, we not show. We have to be little, this is not the way to such people.
Sir, in cost.
Want file application, file the application in the proper. Don't waste time of the court. Many lawyers are.
Next
waiting
date,
there.
You file application, whatever application you want to file, in the form of formal IL. Of whatever prayer request you want to make to the court. 3 weeks. And please understand that without any formal application, we are not going to accede to any request.
Yes.
Yes.
The complainant in this matter, my lord.
So far as regularization is concerned, my lord, it has been ordered for payment of pension and the pensionary benefit, it is pending. Last may grant me 2 weeks time. By that time, lord, I'm fine.
Pension.
Direction for regulation of this, plus the consequence. The main we reply.
So far as part 1 of the order is concerned, it has been complied.
No, full compliance is necessary, na?
Yes, sir.
Payment is to be
2
made.
weeks time, that's
Payment
fine.
of pension is.
Nearly 1 year, my lord, it is. An elderly person.
Expeditious.
Please.
Within 2 weeks
2 weeks.
or 3 weeks. We will not grant further time because it is a pension.
The last may kindly
3 weeks.
grant 3 weeks, failing which
At the request of learned government,
presence
leader,
of
Mr.
the
Mahendra, 3 weeks time is
accused number
granted,
2 maybe.
within which it is expected that the directions regarding payment of pension and the arrears thereof shall be complied with. To be listed on 26th March.
Failing which, not the presence of the accused number 2 may be ordered.
Failing which.
Failing which, not the presence with the accused number 2.
Yes,
Otherwise, it won't be complied, my lord.
3 weeks.
Failure to comply with the directions of the court within the time stipulated above
Officer present before.
will be viewed
Seriously.
sternly.
Okay.
3 weeks will go to 26th of March. Four for them.
God bless.
Lord, I appear not for the appellant. Matter has come up for orders. Now, these orders may not be necessary because the first note is regarding, Lord, what had happened was, Lord, I'm the management. The worker, Lord, was discharged on health grounds. He had back pain. The labor court, Lord, ordered his reinstatement with a portion of the back wages. In appeal, my lord, after the matter, the learned single judge, my lord, dismissed our writ petition. And in appeal, my lord, after hearing both sides, the honorable court, my lord, wanted to know whether we can take him back. So, my lord, we said, let one more medical exam be done. That medical examination was done. A report came. He has now recovered. So, we have taken him back to duty. So, what now remains, my lord, in the appeal is only on the question of back wages and continuity of service. Because at that time, my lord, he was not well. So this first office note, my lord, relates to non-service of acknowledgement. That report we have already received, and honorable court has also passed orders. Then IA 3 for 23 directions may not arise because the direction was for medical report. Main matter, my lord, may have to be heard.
My lord, if my learned friend is confining.
There's a detailed order passed on 27/9 by this honorable court.
So this is the genesis of labor courts.
Yes.
Directing reinstatement with.
Yes.
With back wages.
Labor-
100% back wages. Then in the meantime, he developed some.
No, no, my lord. He was. Lord, labor court made an observation.
And it has attained, you say that you have reinstated them.
Yes, I have now, my lord, subsequent to another medical exam, he has now been reinstated and he is now being paid current wages. My lord,
Now,
what?
Now what happened, what the bone of contention now is confined to?
Yeah.
What is payable to him?
Yes, that is one. And whether he is entitled to any, yes, my lord, entirely it's monetary now. So, my lord, my submission is only this. At that relevant point of time, he did have an ailment. He made a request that he should be placed in another position. That request was acceded to. Even there, he could not work. Therefore, my lord, on medical grounds, he is unfit. That is the finding, my lord, that we recorded and discharged him from service. On challenge, the labor court, my lord, records a finding that he was unfit. He could not have done the work. But still, my lord says you reinstate him.
Because that so-called unfitness, the
Please.
arguable unfitness.
Yes.
Was acquired because of the heavy work, because every day he was lifting 28 kg goods.
That was his contention.
Tension
On,
on
yes.
that single judge
On
also.
that, my lord, there is a submission that I would like to make on the merits. So, my lord, if your lordships would kindly peruse the order passed by this honorable court on 27/9, there's an order passed by your lordships bench, my lord. (27/9/23). His prayer in the writ petition was, you give me that lesser job.
The view of apex court, which O.P. Malhotra in his commentary on Industrial Dispute Act says, is where disability is acquired in the course of discharge of employment obligations, then the employer has to be very kind.
But here it is not so, my lord. That's what we have been able to demonstrate. This material evidence so far as that is concerned. That is something which your lordships have to please examine. Lord.
But it was a, no, sir, it was a 227 petition.
Yeah.
Because it arose from admitted jurisdiction of the authority, labor court.
Yeah.
So 226 pales into insignificance because of seven judgment. In 227, learned single judge has said at paragraph page 35 and 36, he has recorded a categorical finding. Then how that can be set aside in an intra-court appeal is the question.
My lord, the submission is this.
Yes.
There is an admission by him that he is not able to do this work.
That's true.
Now, my lord, the question before the labor court was, when he has a disability to do the work and he admits that he cannot do the work, the discharge of him from service, was it justified or no? On that, there was evidence.
No,
And,
that question now pales into insignificance.
No, now, my lord,
Because
time.
Inspecting counsel is saying, we have reinstated it.
Time, my lord, that the time is what I'm saying, my lord. Kindly see the dates, my lord. This disability and this termination was 2014. Whereas now, my lord, in the year 2023, 9 years later, after not taking treatment, he underwent 2 treatments. After taking that treatment, he is supposed to have now become all right.
Seven judgment in ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಅಂತ ಯಾವ್ದು? Seventh judgment says, which is 227. It is 226. 227. Original litigation.
My lord, as far as the back wages is concerned, your lordship, I'm entitled for full back wages because I never said I can't work. I only said I'm particularly working in a particular department, continue to do the work in that department. They want to shift to the manufacturing where I have to lift the 20 kgs heavy material, your lordship. Therefore, your lordship will kindly say, I'm actually victimized because I am for a member of the union and the exhibits 1 to 45 relates what is the transfer between the union and the management I have presumed.
Some bargain has to take place.
All right, your lordship.
We cannot apportion things with Portia's knife.
In fact,
merchant of
no,
Venice.
my lord. In fact, I would leave to your lordship to fix it. I will abide by it.
Please see page 147, my lord.
What is the total amount payable? Have you calculated towards back wages?
Lord, we have not done that calculation, but I can place it. In fact, on the last
termination of 2014.
Yes. And he was reinstated in 2023.
23.
Yes.
So almost 10 years.
Yes.
So
9 years.
What is the amount payable?
I'll have to work that out, my lord. In fact,
Approximately, what was the last pay drawn?
currently his
last
pay
pay
is 81,000 a month.
Huh?
When reinstated, his pay is 81,000 a month.
Per month.
Current.
Per month.
And you will not concord with.
Please see page 140. Sorry, madam.
He has been reinstated also.
He has now been reinstated. But kindly see page 147. At the relevant time, what he said, my lord, when we issued him a notice. This was his reply to the show cause notice given to him to say that you are not working.
But this is not the case where you can say that he was gainfully employed during the time.
Lord, we are not saying that.
Because admittedly he was suffering.
He could not do this work. My lord, that's the question.
No.
That's what he also says, my lord. Page 147, this is his submission. It is true that I joined the company in 2004. I was working in manufacturing department. I suffered with back pain during 2008 and gradually it increased till 2010. It is also true that I have undergone continuous health checkup and my health has not improved in spite of continuous treatment.
Correct.
But anyhow, I was performing my job satisfactorily in spite of suffering back pain.
Correct.
Now, what
We
I'm
don't deny that.
Yeah.
The contrary, this goes.
So at that point of time, Lord, at that point of time, even before he was discharged, he had developed this ailment. That's the supposition I make.
Every day he was lifting a weight of 28 kgs.
No, it's not, what I'm saying. No, my lord.
The finding is recorded by learned single judge also after looking into the records of the lower court. There is very limited scope for our interference because of 7 judgment.
No, I understand.
So he is also agreeable to give up something. Something you have to do now.
In fact,
Otherwise,
even before I made a request to late Mr. Anant Raman was then appearing to say, can we sit down and sort it out? But he's now no more.
Uncommon is no more, your lordship. That is the reason why I have come.
If we admit it and stay it,
No, not
how
necessarily.
long
my-
it will take, you know that?
I know, my
So
lord.
be pragmatic.
let
Now
the-
they are kind also because they have reinstated you.
Yes, yes, your lordship.
Therefore, be kind to the employer also. He is giving you bread.
That's
In
why.
fact, that was my suggestion, my
In
lord.
fact,
He
I am
made a
leaving the
suggestion
whole thing to your
that he
lordship.
can be, and he
Let
can
them
undergo
give-
one more.
Allah,
He said
let
we'll
them
pay
give
the
a
cost also of all the
Statement of
tests.
account, what is the amount payable to me?
You will be getting sizable amount.
Yes. I
Even if
will-
you,
yes, your
even if you give some concessions, even if you give 50% concession, you will be given sizable amount. Now we have indicated what to do.
The salary none dies.
Very well.
You want to consult your client, then we can give a date, 2-3 days time.
3 days, your lordship. Basically, I am agreeing for your lordship 50%. Anyhow, I talk to them.
Then take, consult,
Yes.
get consent. and
Your lordship may
better
have it on
file-
Thursday.
Better file your consent memo or whatever. affidavit,
Thursday or
whatever.
Friday, I will file the memo, your lordship.
You also.
Please, I'll take instructions.
Yes.
Please.
So this is not binding to you. You can
Ye-
play
yes,
between some
Yes, yes.
50, 60. Just suggest.
In fact, I have got the decision for lordship sitting in your.
Our suggestion never binds any of the party. This is only a suggestion.
Very well, ma'am.
Yes. So day after tomorrow? Or
Yes, your lordship.
Day after tomorrow?
Yes, your lordship.
To give to.
Could your lordships have it, my lord, 4-5 days later? I'm a multinational company. There's some procedure
Next
that we
week.
follow.
19th,
Next week,
19th,
please,
19th.
19.
Much obliged.
Maybe on 18th or 20th, no, sorry. 20th. 20th. Could it be on 20th, my lord?
20th.
19th has.
20th.
Great, great.
Lord, I appear for the appellant. Lord, I request for 2 weeks time, my lord, for this reason. My lord, one is there is a office objection which I have to comply. Second is, my lord, there is some subsequent development. I may withdraw the writ appeal also. 2 weeks may be granted.
You may withdraw the.
No, I may, my lord, after getting instructions from the party
Who is private?
due
party.
to the subsequent developments.
What is that? Reinstated,
No, he has already retired.
already retired.
Retired.
We are for back wages.
Yes.
All right.
My lord, 2 weeks, my lord, I will.
Learned advocate, Mr. So-and-so, prays for 2 weeks' time to take further instructions, stand over to after 2 weeks, which will be the date. 27th of March, the office of business.
27th, 26th or 5th, 25th,
26th.
25th.
25th is a holiday. Holiday? No, 25th. But remove the office objection. Please. Office objection will be removed.
Number 24, Mr. R. Lokanath, 14%.
For R 2 to 4 in this matter, your lordship.
Direction to reinstate
There is a,
with liberty to initiate inquiry.
your lordship may kindly see, I am relying on one citation.
You
that
can't
the
rely
honorable-
on any citation.
The one citation of the honorable.
No, we are not going to listen any such.
Are you complying or not?
Your lordship may kindly see,
File appeal.
there is an, I have filed appeal, the connected matter is,
Comply with. You are reinstated or not?
there is an,
So you are reinstated?
My lordship, on 1st of April, I received the copy of the order and I reported on 3rd of April, that is the immediate next working day, Monday. And I have given my joining report. They admitted the joining report and they did not give me the seat and the system to work with. I am IT programmer in LIC.
We asked you whether
Once. I'm,
Honorable Chief Justice asked you
yes, my lordship.
a question that would admit binary answer.
Yes,
Are you reinstated?
not it.
Tell that.
My lord, this order has been challenged in the connected writ appeal. There is an order of stay by this honorable court.
I'm sure.
Stays there.
Yes, your lord. The writ appeal 439 of 2023. Both the matters are clubbed together. So both will have to be heard.
So
My
this
lordship,
order is stayed, Mr.
May I
Parker.
make my submission, my lordship?
What submission you can?
My submission is
Yes.
accused number 2 is having his residing office at Mumbai. His first wakalat was rejected for not complying with the seal of the office. Second was rejected for another.
The order which you are complaining of violation.
Yes.
is stayed by the division bench. Then where is the contempt? Therefore, both they have to be taken. That's the judgment of this court.
Yes, my
Where
lordship.
order complained in contempt jurisdiction is put in appeal and stayed, both the matters to be taken together.
Yes, my
That's the
lordship.
justice.
Yes, my
Honorable
point, my
Justice Haki's
point
judgment.
before this honorable court is the original signature is not the signature on the.
Learned advocate, Mr.
Rajesh Shetty. Rajesh Shetty.
Bring it. Please understand the law.
Points out that the directions asked by a single judge for which the non-compliance is alleged are stayed in the writ appeal number 439 of 23. He produces copy of the order dated.
One submission. I am appealing for the respondent number 1, Union of India, Ministry of Finance.
1 second. 17/7/23. Granting ad interim stay of the order dated 22/2/23, which is the subject matter of present contempt proceedings. So we can dispose it of also someday. The present proceedings may be listed along with the writ appeal number 413 of 20.
That is listed today.
It is listed today.
Yes, sir.
So both may be listed on April, 3rd April. 3rd April.
3rd of April.
In the meantime, the interim order may kindly be.
Which entry mode?
My lords, the
In that
respondent number 1 is a formal party. I may be deleted from the area of parties because there is no relief against me claimed by the.
Your party in the original proceeding.
Yes, my lord, but there was no relief against me.
It's all right, you may be
Direction by this court.
Let us see.
Should I have to comply?
We are happy that you are here. Why do you want to?
3rd April. 3rd April. Continue.
Complaint will be matter.
Accused, my lord. My lord, I request 1 week's time to file the compliance officer. Partially it was complied, my lord. Now the report has to send the government. Only thing is next week, my lord.
Annexure page number 9, my lord. Matter pertaining to Arkavati layout, my lord, the honorable committee.
1 week for compliance.
Please, my lord, I know it's just.
You are for E.K. Kumar.
My lord, I am.
You are
E.K.
for
Kumar.
BDA.
Yes, my lord, BDA.
BDA.
E.K. Kumar.
PD. Learned advocate, Mr.
Shape.
So. Sampath, no, K. Krishna,
K.
6 time to comply with the directions
Filing the compliance report.
and to file the compliance report.
1 week.
Time is granted up to 22nd March to be listed on 22nd.
Please.
My lord, I appeal for the complainant, my lord. My lord, they have complied with the orders of this honorable court, my lord, last week.
Complied with.
Complied, my lord.
Learned advocate for the complainant states that the order brought under contempt is complied with, therefore the proceedings do not survive. Accordingly, closed. Learned, accordingly they are closed. Learned government advocate confirms the compliance. Mr. Mahendra Kanthransigam disposed of. Accordingly has not survived.
27, Mr. Rajaram is.
Please.
Respondent, my lord. Only seeking 2 weeks' time, my lord, I shall file my affidavit as restrictions, my lord. Only seeking 2 weeks' time, my lord. File objections and.
Against? Yes.
Consider the representation.
Time bound directions given by this on court, my lord. It has not been considered.
Let's, I need to seek instructions, my lords, with regard to it. 2 weeks' time, if 2 weeks' time is granted, I shall file necessary affidavit with it, with that regard, my lords.
Learned counsel, Mr. So-and-so, the respondent stated. Respondent accused stated that if 3 weeks' time is granted, the order and the directions shall be complied with. Stand out to 26th of March.
We'll dispose of this. If there is non-compliance, you seek revival. We will do that. It will be aggravated contempt.
Please, learned advocate, Mr. So-and-so states that the order and the directions under contempt dated 14th September 22 in writ petition number 22876 or 21 shall be complied with within 3 weeks from today. Full stop. In view of the above statement, the contempt proceedings are closed. The respondent shall abide by their statement. Full stop. Learned advocate for the complainant, Mr. So-and-so stated that liberty may be reserved if the non-compliance persists even after 3 weeks. Full stop. It is observed that the failure on part of the respondent authority in complying with the directions within the stipulated time as above shall expose the respondents to the aggravated contempt.
Much.
Grateful.
The proceedings are closed and disposed of accordingly.
Number 28, Mr. Kemparna.
Appear for the complaint, my lords.
Complied with. Yes. What are the directions?
Filing wakalat, my lord, today. For the filing wakalat for the respondent, my lord.
Wakalat now you are filing.
Yes, ma'am.
For the respondent.
They one day.
What is more important is compliance, Mr. Not wakalat. Where is the direction?
Time, my lord. Which time may be granted?
We'll grant time, but let us.
Because due to COVID pandemic, the business have lost, they are unable to complete the.
In MFA order,
Please, my lords. MFA order, it was compromised, my lords. They filed we have filed an application on order 23 rule 3, my lords. It was compromised. This is the second contempt petition, my lords.
that's all right. If there is, it will be compromise decree or compromise award.
Please, my lords.
Then we have to execute it. That's how we have taken the view, na?
Yes, ma'am.
We filed contempt petition, my lords, and in that also they had filed an affidavit undertaking that will finish the work within 8 months, my lords. They have not yet started, my lords. They have filed an affidavit undertaken that will finish it within 8 months.
The complainant is the landowner, my lord. Opponent accused is the developer. Both of them have entered into a joint JD, my lord. Even flats have been allotted. Due to some COVID pandemic and all, even the accounts have been, due to some SEBI issues, the company accounts have been freezed. For they're not able to get the funds.
Two weeks you want,
Yes, ma'am.
but they'll comply with within that time.
They will sit together, they will discuss with the
Do it.
3 weeks, ma'am.
No, do it.
Yes, ma'am.
Learned advocate, Mr. So-and-so appear for the respondents and 6 time to file his wakalatnama. 10 to 27th March. Which, how much time? 2 weeks.
My lord.
2 weeks you want?
2 weeks. my lord.
27th March,
Yes.
27th March. Post. The parties shall report compliance on the next day. You sit together and
Please, my lord.
it
we'll
is
do- we'll
ultimately
do it.
compromise. Only thing that became order of the court.
Available warrant.
To the accused, my lords, it is.
Whether
it is-
accused is present before the court.
My lord, he is present.
Why were you not present before the court earlier?
He came from Bombay. No notice, he is not aware of the date of hearing. my lord.
You are there.
Pardon? Today only I am finding Wakala.
By virtue of earlier order dated so and so, bailable warrant was issued against the accused, who is present today personally and is identified by learned advocate. So, in view of the fact that the presence of the accused is secured today, the bailable warrant earlier issued stands cancelled and discharged and is discharged. But see that it is complied with. and
Please, my lords.
We can put end to the.
So this is the second contempt, my lords. We filed an MFA, my lords. It was compromised. We entered into a settlement agreement. They told within 24 months we'll complete the project. They didn't complete the project. We filed an contempt, my lords. They told within 8 months we'll complete the project. They have not started the project, my
Due to
lords.
COVID pandemic and note ban, and company become financially.
Note ban and
put a heavy
COVID
loss.
pandemic are very.
This way, actually, they both, developer and the complainant have cordial terms.
Now,
They will,
we have given time to report compliance.
yes.
Please, my lords.
Otherwise, consequences will follow. Tell your client who is before us now.
Yes, ma'am.
Next date, you have to report compliance. It's a contempt matter. We can't be that loose in contempt.
Yes, ma'am.
Oblige, my lord.
Number 29, Mr. Sampath Ye.
My lord, they just now filed an affidavit. This is a case where, my lord, while disposing the appeal, the writ petition, my lord, a protection was given to me.
I am permitted to pass on the complaints.
Compliance.
It was the order dated
My lord, page number
3rd
7.
March 23,
Please, my lord.
and the directions issued by learned single therein, which are brought under the contempt jurisdiction. When the proceedings paragraph come up for consideration, learned advocate Mr. So and so for the respondent accused files affidavit of compliance. What is complied with?
Lord, in fact, no, it's not a. I just,
Had passed an order directing the petitioner to go before the Keshav committee, Arkavati layout matter. Lordships had directed the petitioner to go before the Justice Keshav committee in the Arkavati layout matter.
Paragraph 9,
Sorry, my lord.
paragraph 9 of your appeal complaint.
Please, my lords. Pending consideration of this claim of the petitioner before the Justice Keshav committee, we had been directed to stay our hands. My lord, the allegation now in the contempt is that notwithstanding that order, we have gone ahead and done some work inside his land. That was a contempt, my lords. On enquiry, my lords, the officers have informed us that the land which belongs to the petitioner is a portion of the unbifurcated land of a larger extent. And my lords, we had carried out works in the larger extent. Nevertheless, my lord, to ensure that there is no confusion, we have now stopped work, my lords. I state these in my affidavit.
As per the directions of the learned single judge, the occupation of the petitioner in relation to the subject matter site was not required to be disturbed till after and subject to the outcome of the decision of the Honorable Justice K.N. Kesava Narayana Committee. Now, where is the compliance reflected in your affidavit?
Lordship, may kindly come to para number 9 of the affidavit at page 5.
The compliance affidavit inter alia states this paragraph 9, 10 and 11 of paragraph 5. So it is complied with.
no, my lord, please, comply. I will not persuade, my lord. They only just say, my lord, let them not go, and once again.
They
they
have said
repeat.
it now.
No, my lord, they
It
did
hap-
not say, I will not do it. They say, if I done in mistake, might have done in mistake, my lord, they
I will
say.
say it, my lords.
Only if that small undertaking, my lord, is only I.
While in view of the above statements, the court finds that the directions are complied with, learned advocate for the complainant apprehensions that the
Will not disturb his possession, na?
We have not, my lords.
authorities may again disturb the possession of the land.
Please.
Full stop. It goes without saying that till the committee's decision is, still the committee takes a decision, the status shall not be changed.
Oblige,
Status
my
shall not
lords.
be changed.
Please, my lords.
Contempt proceedings are composed of report.
Oblige, please.
Oblige, my lords.
Number 30, the Sharath S. Gowda.
Against the order under compliance, we have preferred an appeal in 385 of 2024.
But the same has been reported in the last date of hearing also, madam. It is at the stage of non-compliance of office.
It in appeal now.
Yes,
Any stay is granted or appeal is yet to be?
yet to be correct. This may be called along with that.
Learned government advocate, Mr. Mahendra stated that the writ appeal is filed against the order of learned single judge sought to be complied with. In that view, the present proceedings have been listed with the writ appeal.
385 of 24.
Number 385 of 2024.
May I request for a date, my lord, it's a stage of non-compliance of office.
Will come
objection.
and listed.
Date of, my lord, order of the year to July 2023, my lord. They have filed an appeal in the year
They have
2024.
filed and it will be listed.
10th of April. Number 31,
If it is not listed within reasonable time, you can come back.
Mr. Subramanya Bhattayam.
I appear for the complainant for this case.
Yes.
Lord, on the last occasion, the matter was adjourned, saying that, Lord, they would file a compliance report.
A review is filed not against the order of Honorable Single Judge.
Review is still pending.
Yes, my FR number is given. FR number 399 of 24.
As a matter of fact, my lord, even while issuing notice, there is a detailed order by the Honorable Court, my lord, noticing that continuously this is being violated. This is third round of writ petition.
That matter is in review now. We may request now. Similar matters, whatever. Requested.
Contempt proceedings come up for consideration. Learned government advocate, Mr. Mahendra stated that the authorities have filed review application in respect of the order dated 11th December 2019 passed by learned single judge, which is brought under the contempt jurisdiction. Since the review application is filed, we deem it, the court deems it appropriate to request the learned single judge before whom the review will be posted, to dispose of the same as expeditiously as possible. Full stop.
Let it not be
Things are,
Your lordship may keep these
Then we
proceedings
dispose
pending,
of-
my lord.
No, we can't keep them.
the
We have to
contempt
seek
proceedings are
revival.
Very
That's how we have taken the view.
Very
disposed of with a liberty reserved to revive the same if necessity arises.
Grateful.
Number 32, Chokareddy.
32, 33 and 34, we have filed the complaints.
Complied with.
Yes.
Lord, in this case, Lord,
What was the direction?
Lord, page
Section to consider
45
the-
days time is granted for restoration of earlier mutation affected in the name of the petitioner. 1972. My lord, earlier occasion, the very same Tahsildar of page number, para number 3, my lord, page number 9. Para number 9, my lord. Earlier, after verification of the documents, he has issued the endorsement. He admitted the grant made in favor of the mother of the
Okay,
petitioner.
What the applications, have they filed applications and you have taken decision on them?
Yes,
When the
the
decision is?
representation was considered, Lord, as per annexure R1, page number 6. 7 is the, Lord, translation.
Your compliance have reviewed.
Yes.
Page number 6.
Page number 7 is the English translation.
Maybe blind orders or not. He has to challenge.
Lord, para number 3 of the judgment.
There is a
Lord,
direction to
Lord,
consider.
ownership has been admitted by the Tahsildar earlier occasion he has issued the endorsement. After verification of the records in the Tahsildar office,
Brother, how
he
can we-
admits.
Please understand, any standard book on law of contempt, Iyer, Brogley, etc. We cannot undertake critical examination of the endorsement issued. That's how we have held also. There are 3 judgments to which I am one of the parties to the bench. We have held critical examination, we cannot undertake. You challenge them.
Lord, earlier, the 2 stands of the Tahsildar. Earlier, my ownership and documents admitted by the Tahsildar had issued an endorsement. That endorsement to quash and 45 days time has been.
You know the parameters of contempt jurisdiction.
Jurisdiction we have.
Can't go on merits of the order which is complied with. It has to be subjected to independent challenge, if at all you want, on merits. The contempt court can't go beyond anything. except
Double
it is-
stand taken by the Tahsildar, my lord. Double stand. Earlier, my ownership has been.
You make it a good ground to challenge.
Now he said all the documents are fabricated.
It may be a good ground for you to challenge in the writ petition or whatever form of proceedings you take out. So all are common directions? So
Common.
separate order, but common order?
No,
Separate order. Yes.
And liberty to challenge the endorsement.
Learn a single judge while disposing of the writ petition number 39578 of 2018 by order dated 26th April 29, issued the following operative directions. Then page 9, paragraph 4. Fourth paragraph 4, bracketed portion. This order. Today when the contempt application comes up for consideration, learned government leader, Mr. Mahendra, invites attention to the compliance affidavit filed
4343.
on behalf by exponent by the Tehsildar, Kolar Taluk, Kolar, in which inter alia it is stated that the directions are complied with. Full stop. The deponent has further produced copy of the endorsement dated 6/2/24, whereby it is stated that the record is verified by the Tehsildar. Revenue record in relation to the subject matter of the petitioner is examined by the Tehsildar, and the decision is communicated to the complainant. In view of the above, nothing survives in the contempt proceedings. They are closed. At this stage, learned advocate Mr. So-and-so submitted to the court that the complainant is not satisfied with the decision. Full stop. If that is so, the complainant is not precluded from challenging the order on merits for which this court does not express any opinion.
I request liberty to challenge it.
Yes.
Given.
Please.
Number 35, Sanjeev B.
Same order in
I
32.
appeared for respondent KVHR Melod. Appeal copy has not been furnished to the.
No, I have received.
Same order in.
Lord, I've
served a
Maybe called,
copy.
maybe called next week, my lord, by that time.
There's one office objection, my lord, annexure C. The petitioner had filed a color photograph of the petitioner. Lord, I could not file it. My lord, one submission, my lord, they have filed contempt, my lord, against this petition. My lord, what has happened, my lord?
We'll call this.
Contempt already notice has been ordered, my.
We have to call this along with it.
Yes.
Contempt
See,
petition,
see,
my
see.
lord. 195 of 23.
Call this.
Number 36. G. Malia. Mohammed Shah.
I appear for one of the appellants, my lord. Request your lordships to kindly hear this matter 2:30, my.
2/3.
Yes, my lords.
Why? Counsel is appealing.
He is on legs before the Honorable Supreme Court, my lords.
Would your lordships then have it, my lord, on some day, my lords, maybe in March?
But I'm told even that. It's a matter relating to the high security registration.
No, Mr. Kamath wants some other day, na?
My lord, subject to your lordship's convenience, my lord, if we can physically come and lordships may fix any date, my lord, we'll come and argue your lords before your lordships. my lord.
Also told that the learned additional solicitor general also
Wants to come.
My lord, in that case, it may. My lord.
So when do you want, Mr. Kamath?
My lords, 25th or 26th, my lord, subject to your lordship's convenience, my lord.
Yes.
26th.
26th.
Very well, my lord. Extremely grateful.
28th.
28th.
No, but that's.
28 is all right.
Long weekend immediately after that, in case it doesn't get over. Because 29th, if I'm not mistaken, is. My lords, 25th or 26th will be convenient for us, my lords.
Your AST will be coming here on 28th.
28th also is fine, my lord.
28th, very well, 28th.
Number plate.
Yes.
28th.
Mr. Kamath, 28th, all right.
Very well, ma'am.
Much appreciated.
You will abide by that.
My learned friend,
Not
Sharath,
supposed to
my lord, Sharath Dodwad, who appears for the
One and
election
two.
commission.
1 and 2.
1 and 2, my lord.
1, 2, and 6, your lordship.
1, 2, and 6.
Please, 4 and 5 would be Miss Vaishali Hegde. That's for the state.
1, 2, 6. 1, 2, and 6 is the election commission.
Please, Mr. Sharath, he's been served. Your lordship.
You are for election commission.
No, my lord, I appear for the third respondent, my lord, to go to election.
Learned panel counsel, Mr. Sharath M. Dodwad, is requested to accept notice for response numbers 1, 2, and 6. First, learned, notice is ordered? No.
They have
Learned
already
DST.
received, your lordship.
DST represents response number 3. Learned AGA is requested to accept. Any state election commission, they must be having panel advocate.
Ms.
Please.
Vaishali Hegde, we served her already.
Panel council is requested to accept notice for response number 5.
Four and-
4 and
four
5.
and- please.
4 and 5. First, petitioner to serve a set of 2 petitions along with all the documents on the council representing the respondents immediately.
It's already been done.
Call of the 2 weeks.
Great.
First of April.
Please.
Number 38. Sumo to criminal contempt.
13%.
Submit ಮಾಡಿ.
I'm appearing in person, Your Honor. I'm filing my objections for.
Certificate is obtained now.
My lord?
Certificate of competency.
In a criminal matter, contempt matter done.
This is from Shidligata. I'm filing my objections. Permit me to file my objections.
Good. Submitting what?
Objections to the petition.
reply. Serial number? Have you served a copy on the other side? Yes. You have served. You go through and make submission on the next date of hearing. We also have to go through. Only now we have given these papers.
Yeah, I have been falsely implicated in this case.
Let us see. We don't know. We do not know.
Nothing was transferred in the open.
Let's see our case.
You are involved in many litigations.
What? Are you involved in other litigations also?
What?
Any other cases pending against you?
No.
No case.
It's a very new coming. I just acquired the office by 6 months.
His reply, which is taken on record. Copy is also served to the learned additional government agent.
Right.
10/2. 4th April.
Which date you want?
Any date.
4th April. You remain present on the accused shall remain present on the next. You have to remain present on every day unless exempt.
Yes.
4th April.
What?
4th April.
Wait.
Was it?
It's serial number 39.
Permission.
And give to the
Indian case nalli.
office objection regarding certificate to appear is dispensed. Earlier matter. Earlier matter. This is an earlier matter.
Model not.
Has filed his wakalat and told only on Thursday for accused numbers 3 and 4.
You appear for 3 and 4.
3 and 4. Only filed wakalat on Thursday. Your lordship's grant about 3 weeks time, we'll file our compliance activity.
My lords, the petitioner's land was acquired by accused number 3 and 4, my lords, and 8 weeks' time was granted to accused number 3 and 4 to release the amount, my lords. It's been 22 weeks since they have not released the amount. I think page number 18, my lords, is the order of his lordships passed in the writ petition, granting 8 weeks' time to accused number 3 and 4, my lords, to release the amount.
Payment is not made as it.
I'll just find out the status once. It has to be routed through the KIDB. I'll find out the status once, whatever extent.
Time is granted up to 3rd April.
3rd of April.
Please.
Within which time will you comply?
Yes, sir.
Within which time the respondent accused shall comply with the directive.
My lords, 40, I appear for accused 1 and 2. My lords,
Hearing for complaint, my lord.
part of the order is complied with, my lords. Back wages, entire back wages we have paid. Reinstatement matter is coming up before the Supreme Court this week. My lords may kindly grant 10 days time in this matter. It is already filed Supreme Court. It's coming up in 10 days, my lords.
My lord, hardly.
And review petition was filed and in Dharwad bench it was dismissed on 23/2. Order copy is not released in review petition. Supreme Court, it's coming up this week, my lords. 10 days time we have granted.
Hardly 2 to 3 months is there, my lord, for service.
You are reinstated or not?
Not yet, my lord.
But then there before Supreme Court. Nothing to you also. Stand over to 3rd April.
Grateful, my lord.
41.
My lord, I appear.
Naveen Chandravi.
No. My lords, here the matter is with regard to implementation of the order. My lords of the family court, the operative portion is at page 85, wherein the.
Order of Supreme Court.
Yes, now my lord.
To produce this.
Yes, now my lord, I just want. to
We have not
submit.
yet received a copy of the contempt petition, I am told.
My lords,
They
may I
have filed
just.
a contempt application. I'm told my learned friend has not yet received a copy of that petition.
Copy has been
Meanwhile, not in
served.
the Supreme Court.
For the
My lords, may I
the
just,
transfer proceeding, the entire thing is stayed.
Yes,
may I, on that issue, on the last date, my lords had submitted. My lords, in the transfer petition, an order is passed, which I think my lords already have it, but I can hand over one more settlement. Yeah, my lords, they filed a transfer petition in which an interim order was passed. This is order dated 16/2, saying that in the meantime, there shall be a stay of further proceedings in the custody petition. This is after the impugned order. Order that we are seeking contempt is on 6/2, my lords. Yes, 6/2, directing that custody of the minor children which was taken away from the father be returned back.
Just kindly, we
Yes.
request you to
Yes.
read the
Yes.
text of the order of the
Yes.
apex court.
Issue notice returnable within 4 weeks. In the meantime, there shall be stay of further proceedings in custody petition GNWC number so-and-so, title so-and-so, pending before the court. Then,
Very specific.
yes, I have just 2 submissions. On the last date, my lord said, kindly get a clarification from the Supreme Court whether our hands are tied over here or not. Thereafter, though I made a submission that according to me, it is further proceedings.
Last time we wanted the order, copy of the order. Now we are a new bench. Again, you can convince us, no difficult.
Yes, yes, yes. No, certainly. I'm grateful for that opportunity.
All proceedings are stayed.
All further, now, my lords, can I just submit in the thereafter falling from the mouth of my lords, in the transfer petition, we filed an IA for not only, may I just pass on?
Any order has been passed there?
In fact, it was there today. Matter was listed today. They have filed a reply also.
They're asking
But
you,
no, there was
any
no
order
there was
is passed.
No sitting yet. matter was listed today, but there was no sitting. May I just want to submit one submission for my lords. May I just make one submission? I leave it to my lords. In my IA for clarification before the Honorable Supreme Court, in which the respondents also filed a reply. And in fact, matter was listed today. Matter was not taken up because there was no sitting. In fact, at page 96 of their reply, they state that there is no such clarification sought by the Honorable High Court.
Since Apex Court in transfer petition number 342 of 2024 has made a direction on 16/2/2024, staying all further proceedings in custody petition G and WC number 442 of 2023, matter stands adjourned by 2 weeks.
Then my lords may take it adjourned by a week, my lord, since there is some urgency. At least
So
next
you can-
week, my lord may fix it.
After
If any order
any
is
order
passed.
is made, if any orders are obtained at the hands of the Apex Court, it is open to the parties to move the court.
Great, great, great. Yes, we'll serve.
Number
Just give a copy.
42.
There was an interim order
Murthy ke-
earlier in this case, Manoj. The first date when the learned single judge was hearing my writ petition, Honorable single judge had directed parties not to precipitate. So, Manoj, though the contempt is now before your lordships, Manoj, what happened was the order of the family court we questioned in the writ petition. In that, Manoj, after hearing both sides on 29th, there's an order not to precipitate.
No.
I mean, so we
That
cannot,
should co-
there is an order by the Apex Court. In fact, that order prevents us from touching the file.
Because this is a continuation that only, but that order of not to precipitate was the next till the next day.
Can say anything and everything we can.
Please, ma'am, please.
The word.
Number 42 to Murthy ke.
In para number 24, ink page number 21, I have submitted my clarification as to why I have produced some more documents like that. There were 2 writ petition, my lords. So subsequent documents pertaining to subsequent events have been produced in the companion petition. That is why, for the perusal of the court, we have produced that subsequent events documents produced in the companion petition also in this petition, in this appeal also. In the order passed in the companion petition has been challenged in another writ appeal, that is in 338 of 2024, my lord.
You are the borrower.
My lord, yes, my lord.
And you had pledged the gold for security.
Yes, my lord.
They wanted to auction the gold.
Yes, my lord.
Now they say we will not auction.
No, my lord. There is a small misunderstanding.
Page 32.
Misunderstanding, 1 minute.
32.
Huh.
When we say you should read the order, you have to read the order, then you can argue.
Yes, my lord.
Don't halt us that way. We will not be bogged down that way.
Huh.
Please read para 7 of the order.
Yes. Therefore, the petition is disposed with a direction that the respondent shall not put up the gold auction as it is held as security towards the loan in the companion petition. As the putting up of gold auction is only a consequence of failure on the part of the petitioner to discharge the loan in the companion petition and not otherwise.
Go in the companion petition.
Companion petition.
Which is that companion petition?
We prepared that appeal also for in the order passed in that company petition, companion petition also.
Today the bank is not going to auction the gold.
That date was over. I paid the money.
So then where is the question of auctioning the gold?
We have not asked stopping the auction. We never asked that. We are asked, we paid the money, direct them to return the pledged goods.
You have repeated entire amount back.
Yes, 3 agriculture gold loan account has been paid.
How many loans were there?
There are 7 loans.
Yes.
For remaining 3 accounts, they have taken the measures under Securitization Act. That has been stayed by the DRT as well as High Court.
The prayer in the petition to return the gold.
Yes, my lord. Because we paid the amount. Before selling the property, auctioning the property, 1 day earlier we paid the money.
1 day earlier you paid?
Yes, my lord.
Where is?
We have the account extract itself I produced. In page number.
No, there were 7 loans.
Yes, my lord.
Please listen to us.
Huh.
Keep your passion a bit down.
Yes, yes.
There were totally 7 loans.
Yes, my lord.
For how many loans you had given this gold pledged this gold for security of repayment?
3 gold loans.
Other 4 it is not concerned.
Uh-huh.
Other 4 loans are there.
Yes, my lord.
They are outstanding.
Yes, my lord. But other 4, out of 4, 3 loans are term loan accounts. Then in that term loan account, they classified my account as NPA and they taken the measures under Securitization Act.
In respect of
That 3 loan accounts, not this account. Then I had been to DRT against that measures. DRT has been stayed.
You have to show that.
DRT has
Or
stayed.
learned advocate, learned Mr. So and so, notice to the respondents, returnable on. This is gold, you take direction. Direct this thing.
Come with great,
26th of March.
much, with great respect. A companion petition order has almost been appealed herein. That may be taken up together, Mila.
Which appeal?
Appeal number 338 of 2024.
Appeal number 338 of 24
Huh.
shall be listed together with the.
Because the
caption
total case is, one
Caption
of
of-
contention is misuse of securitization
on
power.
the next day. What was that appeal? What is that appeal?
My prayer is the manager of the bank, he misused the extraordinary power conferred to him. Even he filed a false affidavit before magistrate.
We'll see on that.
Much of it. 26, much of.
December 43, the Lomesh Kiranyan.
Request for a password. Learned AG is leading me on the matter. My request, I'm for the respondent members.
AG. Afternoon.
Password.
Well, all right.
Do I have any choice, my lord? When the AG asks for, do I have any choice?
Sorry.
I'll be here.
Sorry, sir.
So, number 44, Sumoto writ petition KL.
Before, as the amicus have prepared a report, my lords, this is regarding the out-of-school children and provisions implementation of right to education. In the last occasion, my lords, the government had filed a report regarding certain deficiencies in the government schools as regards toilets and, my lords, drinking water facilities.
They have given the report now.
They have, my lords, I have perused the report. I am filing a status report. From their own report, my lords, we find that there are lacunas, my lords, that in 123 schools, there's only one toilet, or some schools don't even have a toilet. Whereas they in their report say, my lords, that only about 69 schools there is a problem with toilet, because under the provisions of RTE, there should be 2 separate toilets, one for girls and one for boys. Which, my lords, in fact, the members of the State Legal Services Authority have subscribed, probably not noticing the provision which requires 2 toilets. The provision requires 2 toilets. I am filing a report giving the details.
That look into this recommendation that they have given and come back to my lord so that I can improve whatever lacunas have been.
And
Please, my lords, may I make one more request? This is pertaining to schools which are surveyed by the government, my lords, within the limits of Bangalore Bruhat Mahanagara Palike, BBMP. BBMP has to do it. Government says we are not doing it. It's under the control. Unfortunately, BBMP has not taken out any survey in terms of this orders, and we are not getting information, my lords, as regards schools within Bangalore run by BBMP regarding the same thing. So at least BBMP has to be directed, because every time, my lords, I'm not getting, though I've been sending mails, there is no response. My lords,
I vaguely remember, because I was part of the bench which passed this order. Earlier, one order was made.
Yes,
There's
my lords.
some reference, I believe, I vaguely remember, some direction having been given there also, some observation having been made to that effect.
Yes.
Which is that order?
BBMP 9/10/23 order is there, my lords. My lords had made the order.
Lords, please come to 9/10/23 para 8. 9th of October 2023.
Para 8, both government and BBMP were to submit.
Government has at least done something. BBMP somehow, my lords. In that para 8, 9th of October 23 order.
And my lords had said it should be a comprehensive report that should contain all the particulars for compliance, including drinking water, toilet, washroom, and all other infrastructural requirements. BBMP has not done it.
Right, para 8. Allah, para 8.
Para 8.
Please, para 8 of that order.
Also, the schools run by the BBMP.
Yes, sir.
Nothing is coming out from BBMP.
Well,
This is, my lords, the report is only regarding government schools.
I've sought for the report, but zone-wise report, but they yet to give it to me, my lord. Lordship, grant this little time, my lord, I will get it.
No, this order was made on
Yes, my lord.
9/10/2023.
I do. Some of the earlier, my lord, they used to give to the amicus, my lord, Lordship,
Please,
grant me by week's time, my lord, I'll get it.
These are so much important.
Yes,
You
I
have
know.
seen what the apex court said.
Yes, I do.
And
No,
last,
seriousness of the matter.
5 months are over now.
Yes.
Nothing has been done.
The report has not yet come, my lord.
That makes cheaper.
Lordship, grant me a week's time, my lord, to.
ನಾವು ಬರಿತಾ ಇದೀವಲ್ವಾ ಮೇಲ್ಸ್ ಅಡ್ರೆಸ್ ಮಾಡಿ
The three baddest litigants
ನಮ್ಮ
before the
report
court
ಅಲ್ಲಿ ತೆಗೆದಿದ್ರಾ?
never obey the order. Unless we write our orders with the very different essay.
They have given.
Not got a full.
No,
1 week, my lord, I'll.
You have
Because
to-
I asked the report, zone-wise report, my lord. The 8 zones are there.
You are for BBMP.
Yes. 8 zones are there. Zone-wise schools, my lord, next week, my lord, I'll file it.
We have
What
very
will do?
bad.
With the photographs, my lord.
Next week, what will you do?
With the photographs, the report, I'll submit the report.
10 years he did not do it.
No, the schools are not being run, they are taking care of it. Only thing, the report to the court, my lord, has not come to me yet.
Because they have to give the details of the schools
Yes,
also.
it is in your schools
Yes,
that all
yes, sir.
downtrodden people study,
Yes.
not in other schools. And you don't want,
But,
we have made observation. Oh, we are very,
But
we feel sorry. I was
Yes.
telling Honorable Chief Justice about the attitude of the BBMP. we have problem with BBMP, BDA, KIDB. They're very bad litigants, to say the least. To say the least, we have imposed lakhs of rupees cost also, you have seen that.
In view of clear order passed on 9/10/23 by this court, Brihad Bangalore Mahanagarpalika was expected to file a comprehensive report dealing with the facilities of drinking water, toilet, washrooms, etc. made available for the children studying in the schools run by the BBM. Full stop. Vote yes. Despite the direction.
I'll get the report.
Is not filed.
I'll get the report by
However, learned advocate, Mr.
Ramesh.
So and so. Difficulty is in remembering the name.
Yeah,
Slowly
sometime.
pick up. So pardon me if I say.
No, absolutely.
Weeks time.
Weeks time. I've
Submit
already
report.
informed them not to.
Also, it is made clear in regard to the age of the litigation as well as the importance of the subject, that no further time could be granted, would be granted. And the inaction shall be viewed sternly.
Have your lordship leave, my lord, to make one.
We'll
submission
file
in
the
this
report
matter,
in-
my lord. The main matter relates, my lord, to the provision of facilities for schools. And your lordship, my lord, I've been kindly monitoring it. There are one application that is filed, my lord. I am here, my lord, for the proposed impleading applicant. A group of students, my lord, challenged the grant of a certain land to Ramakrishna Ashram at Mysore to build, my lord, a Viveka Smaraka, my lord. It's a big project that is being done. Government granted that land in January of 2013. That was challenged, upheld right up to the division bench of this honorable court. Directions are given to implement it. We have started the work. At that stage, my lord, trying to somehow get a toehold. They filed writ petition, PIL dismissed, merits writ petition filed, that was dismissed. Now they filed an application, my lord, to intervene in this. My lord, that has nothing to do with this, my lord. That their IA that they filed is IA 1 of 21. They are misusing
No
these
order passed on
proceedings.
that. Lords.
No,
As
we
of-
has passed the application,
Lords,
filed the application.
Group
private
of students
students.
who
That-
filed
There's no
already.
order passed by this court on that application. It's been lying over.
That may be disposed of not because that is closed.
Perhaps I was also author of the order.
No, my lord, I think it had come up at some stage before your lordship sitting a single, but ultimately it was by a division bench, my lord, presided over by his lordship Justice Arvind Kumar. And that order is also produced.
Mr. Suraj Nayak.
They are not here.
That's not by my lords. It was another court. Single judge.
On the next day, we'll see.
Please, ma'am. My anxiety is only that they should not, my lord, interfere with my work. I am at the advanced stage, my lord. What happened was,
That is also our perception.
there was a small school, my lord, in part of this area called NTM school. There were only 60 students there. These students were shifted to another school, which is hardly, my lord, 500 yards from there. All the students have gone there. So that controversy has nothing to do with this, and that is assumed finality also.
And this is in relation to the Bengaluru only.
Mysuru.
No, this is.
PIL
This
is
PIL is for
for the entire
All of
state.
Karnataka.
State also.
For all of Karnataka.
State.
Statement.
whole
Jena
state.
submitted- Other day, Madam Jena submitted that it covers not only Bangalore.
All of
All
Karnataka.
over.
Entire
Well,
state.
in
And
fact, the
all
school
of
numbers
Karnataka.
what we have given is for the entire state.
Entire state. Your lordships are right.
So I'll file this report, my lords, in the registry. In the
So
meanwhile,
when shall we take up next?
my lords,
Yes,
anytime.
after 1 week.
Yes.
It's the government and BBMP which has to actually look into it. There are some issues regarding toilets and drinking water.
My lord, 1 week is too short for me, my lord.
In advance, if they give it.
Yes.
The report which will be filed before the court, before the next date shall be
Yes.
served on the parties
So that we can respond.
Yeah, but I will file it
in advance.
in advance.
So when you will prepare the,
But one
when you will
week,
serve,
1 week for me is enough. I will.
start burning midnight oil.
Yes.
No, but that, my lord, is, they have to take the member of the Legal Services Authority for inspection. That's the order. Every school survey has to be in the presence of a
That's the
representative.
government. That's the government.
Well, even for BBMP, it is the same.
Then your lordship grant me 2 weeks. Then
He believes that the week consists of how many days?
No, we have only 8, 2 weeks.
Only 7 days you have got.
They are very weak in doing things, chief.
We are granting 2 weeks.
2 weeks.
Please. So after 2 weeks, give a date. Which date?
27th March.
Great.
27.
20.
Number 45. Vishweshekar.
Lots.
Does it survive?
It doesn't survive, my lord.
It will not survive. Might not survive.
Lots, what survives in this petition, if I may briefly articulate, is the fact that whether the park is open for the use of the general public as filed by the affidavit, respondent's affidavit, my lord. My lords, my submission is the park which by affidavit they've admitted is for the use of the members of the public, is manned by a gate and public are not allowed to access it. The compound walls are so big that we cannot see what is inside. And this park serves as a private park of the respondent number 4, my lord. The case, my lord, was that this office of respondent number 4 was built on a land that was for park, admittedly by the other respondents. Not subsequent to filing of this petition, considering the fact that the said respondent number 4's office is used for a public purpose, there was an undertaking by them that the rest of the portion of the remaining land will be converted into a park that will be for the use of the public, specifically as per their own affidavit, my lord. Now, may I pray that a court commissioner be appointed to report if their own affidavit is being complied with?
Madam, where is your affidavit?
My lord, I have filed my.
10-8 order, 10-8,
My lord, there is- my lord,
10-8 or what?
7th September 2020.
Yes.
My lord, along with the photographs to show that the office of the 4th respondent
8/20, yes.
ಯಾರಿಗೆ?
So it was stated that the parks are available for public access.
Let's respectfully disagree. It's the office of the commissioner number 4. Manned people are restricting access.
And it appears that these parks are not part of the premises of the police commissioner. It is within 1 kilometer area. It is part of the area of the.
My lord, the Kasturba.
You know, the garden in Mysore city is about 55 kilometers, 55 acres
Where?
of land, 55 acres of land, my lord. Entire park, which is also there in the order of this honorable court, my lord, dated 19/8/2020.
Yes,
It specifies
19.
what is the 19th August 2020. Specifies what is the total extent of land available where park building is constructed and where the park is also, there are 3 parks, my lord. Park, people are accessing the area, park.
In the same premise.
That's a larger extent of land, my lord. It's
No.
total 57 acres of land, my lord.
I can briefly
50
present the facts
57
of the
acres
case.
of land.
please.
19
19/8/2020, that is the order I had.
It's a lengthy order.
Yes.
Lordship may take, kindly, may draw your lordship's attention to paragraph 6 and 7, my lord.
Correct. 6 and 7. Yes.
May I read, my lord?
Our attention is invited to the counter affidavit to the state government dated 26th March, to which the following facts.
One
That's the counter of it, not the order, my lord. That's the count, their affidavit.
It's saying what is the extent of land?
Main, volume 1.
9. 15 in an order sheet.
Stand 20th August, 19th August.
Police commissioner's building is in a
Wait,
smaller extent of
wait
land.
for-
Please, sir.
19th August.
So you want us to read paragraph 6?
6, sir. Where government has stated, my lord, what is the extent of land that's available totally, that our attention is invited to counter affidavit state government dated so and so, which following facts have been disclosed. Total area of the property is 25,729 square meters. One heritage building is band bungalow, which occupies an area of 8,325. The remaining land office building of the fourth respondent's construction is 4,106.09 square meters. Remaining open space is 5,970 square meters. Landscaping planting of 59 trees and horticulture plants and maintaining of lawn and undertaken. The tender process has been commenced. It's fair, further says adjacent to the office before this, there is an open space in which park exists covering an area of 57 acres, which the members of the public have access to. What I'm referring to here.
Lords, may I clarify what this case is about?
Municipal. Which is that section in KMC Act which exempts government from taking any action, any sanction plan for putting up construction? All government. There is one section. There is a judgment also.
In this case, my lord, the permission was, by this honorable court, there was a direction to grant the permission and the permission was granted parkway. 321 is
No,
regarding.
the whole case has been structured on an inarticulate premise that what you have been doing is without sanction plan. That's how they have structured the petition. That's one of the points.
One of the
which you have taken up in the petition.
Yes.
The section says,
This honorable court, my lord, had directed us to issue the sanction plan and plan is.
because you have not shown that section.
Government, for the government building.
That's what government,
But here in this case, since it's notified as open space and public park, my lord, we had to, the permission was directed from this honorable court, my lord.
take out this, find out that section. There is such a section. We have considered in one judgment,
Lords, very,
One is regarding the license, my lord.
no requirement of plan at all.
that's one of the things in the petition, my lord. May I, in just 25 seconds, my lord. My lord, this case came to be instituted when the residents noticed that there was construction in a land that did not belong to the respondents in the first place. What was this land back in 2014? A playground with a band bungalow, a heritage building where previously the British military did rehearsals and police incidentally did some rehearsals.
No,
And-
is it so declared as a heritage building under the Heritage Act? Or it's your version? You may call anything as a heritage
submission.
building. There is a legislation for that purpose.
Please.
Unless it is so notified, the apex court said, unless it is so notified, no structure shall be treated as heritage structure.
Please.
That section you have to say, in your opinion, many things may be heritage buildings, but the law is different.
Please, my lord. Subsequently, my lord, my annexure D, we sought clarification, my lord. This is the second petition. Firstly, when we filed the PIL, we were directed to file RTI and obtain information whether this is reserved as park and open space. Lords, our annexure D, subsequently annexure K, we filed RTI. Respondents clarified that this land under the master plan.
Kasturba Garden is there or not?
It is today, no.
It is
Today,
there.
their office.
Now
Previously, there was Gandhi Vana and Kasturba Vana. Only Gandhi Vana remains.
What is band bungalow?
Band bungalow was
It's also, it is also there.
no.
No.
Band bungalow doesn't exist. Kasturba Vana doesn't exist. Only the respondent number 4's office exists. And it existed at the time of filing the petition. Subsequently, during the pendency of this matter, It was their audacity to complete the building. Subsequent to the completion of the building, my lord, they've obtained a sanction plan.
Give that judgment.
From his government council, this Kasturba garden is there. Public access is available.
Yes, my lord.
Now what survives for your prayer?
Not subsequently, they said the rest of the portion other than the building, they have admitted that they will allow it for the public's use. Now we would like to ensure it happens.
What?
The state, it is their submission, but factually today, public are not able to enter the premises because it is in the office building and the park is in the same premises and it is manned and there's security and public are not able to access the park. Now, because of their own admission, we would like that to be duly enforced, my lord. And the master plan, my lord, the master plan marks, the master plan classification and zonal regulations says it is park zone. Zonal regulations, my lord, says it's a park zone.
So council is saying that it is available for public.
To make it available will be to our fullest satisfaction. A court commissioner may be appointed to verify if the same is true, my lord. Because we would completely disagree with the fact on the ground.
In my affidavit dated 26th March 2018 at paragraph 5.
All the councils of the parties can visit the garden.
Along with another court appointed commissioner, my lord. My own difficulty is the same cannot be realized on the ground and it amounts to poor light in the, my lord, when this objections was called for, when the respondent called for converting the land from park zone to public to semi-public purpose, more than 200 residents had filed objections. Today, they're not able to access it is the sad reality which I'm bringing to the notice of this honorable court.
For any activity, there is objection from the public. This is what Apex Court said at least half a dozen times in reported judgments.
Please.
The reply was in volume 2.
My lords, but what has to also be seen here, my lord, is when the date of filing of this petition, the building was not
That construction is also complete now.
now, my lord, but blatant disregard of the law and rules, my lord, has to be kindly observed by this court. My lord, when the, my lord, the respondent number 4, they made an application before the Mysore City Corporation.
We have said there is no such requirement at all in a reported judgment.
Please, now, my lord, previously, my lord, they made an application themselves.
That makes no sense.
Subsequently, my lord, it was told.
The BBMP
Law
Act,
does not require.
that provision is under BBMP Act. 3.6.
Corporations Act.
Can say,
There is an act, there is a judgment. Share that copy.
please, my lord. My lord, subsequently, the zonal regulation, my lord, puts this park, the Kasturba Vana, as a parking zone, my annexure D, my annexure K. We sought a clarification under RTI. They provided us with a response. That's our
You want the building to be demolished now.
My lord, that
Can
was
it happen?
previously, before we reached an agreement, that was for consideration. An affidavit has been filed by them. We now only seek their own affidavit to be met properly to our satisfaction, to the satisfaction of justice, my lord. We have no unreasonable prayers before this court.
Now, these three parks you are mentioning, Miss
My lord?
Counsel, three parks are mentioned, paragraph 6 of your reply.
Yes. My lord, my affidavit dated 26/3/2018. My lord is looking into that.
7th September 2020.
All I have is 7 September.
Yes, my lord.
Any other is filed?
Lord,
Any-
in my
Any other affidavit? 26th of?
March 2018. Paragraph 5.
March.
So 3 parks at measuring 57 acres in all.
Yes.
The same as Kasturba Garden, same?
Yes, my lord.
Same.
Adjacent to Kasturba Garden
No.
No, Chair.
and a bungalow.
Seen this.
No, my lord.
They were well aware of this. This is a Nishad Bagh Park, Panna Park. Southern side, the Gandhivana Park. The third one is southwestern. It's a different park. Then this is a southwest direction, an unnamed park. It's a city of parks, Chair, right from the days of Tipu Sultan, Hyderabad. Parks have been developed.
Hardly anything remains.
And
What-
building is for public purpose only.
That was,
Park is also public
Lords,
purpose only.
we had agreed.
Public purpose versus public purpose.
Please,
The
please,
apex court says,
please.
which the government does, has to weigh with the mind of the court. There are such judgments. I think you have BL Vadhera versus science.
Lastly, what remains is their own affidavit, which has to be met.
Anyway, can we now crores together amount would be invested in putting up the construction? Can we pull down the construction?
I fully
Just
understand.
think of that also.
Please, please. I fully understand.
And there are parks. It's not that the city has been deprived of parks.
In fact, that's their argument. There is another park. So one park gone is no park gone. That was their argument in the whole case. That is why they bring in other parks, my lord. Our own understanding of the case remains that law should be the same, even for authorities. And if they follow the law and if justice is done, we are happy, my lord. Their own affidavit, if they can comply in the interest of justice, we'll be glad, my lord.
So is interpreted.
We have interpreted. It appears it has been affirmed by the Supreme Court, I believe. We have defined the word person in section 299 of Corporation Act to exclude the government that way.
Lastly, my lord, compliance has to be reported with respect to that affidavit is our only prayer, if that could be a compliance to that affidavit by appointment of a court commissioner.
Compliance of?
Their own affidavit to the fact that the portion will be left to the public use. That can be ensured.
They're public parks.
Yes, my lord. They've named it also Sarvajanikara Udyanavana. They've named it public park, but now naming that and not allowing public to go inside, either take it away completely or give what is promised.
We are not ready to believe that.
Therefore, a court commissioner may be kindly appointed.
My lord, the photographs along with the affidavit dated 7th September 2020 may be seen. It's maintained.
Are you, his grievance says, public
Yes,
is
sir,
not
it's
given
valid.
access to the park. Do you deny it or you affirm it?
My lord, that I'll have to seek instructions and
Please,
make
ma'am.
my submit.
And we
This
will
is our
put up for
difficulty.
orders after
2
week or
weeks.
10 days.
Very well.
In the meantime, you confirm,
Yes.
if necessary, you put on oath that public have access.
Lord,
You put file an affidavit that public have access to the all this. part.
very well.
So that there is no slightest doubt remain in the mind of
When?
Please,
public interest.
please.
21st.
Very well.
Please.
I appear on behalf of the respondent number 2, my lords. This matter
I'm the
pertains
petitioner, my
to
lords. It's
the
a Tumkur City
potholes,
Council. It is a pothole on Tumkur City roads, my lords. Government has to reply, my lords. I have not been served with a copy of the work they have claimed to have done, order dated December 6, 12/23, my lords, and inspected by legal service authorities.
No, report was called for from Legal Services Authority,
Please.
DLS, District Legal Services Authority.
It is
Yes,
filed by the district.
It has been filed now.
And on the last date of hearing, this honorable court directed the petitioner to come to the court and inspect the report filed by the DLSA, since the copy could not be served upon him.
I have not been served with a copy, my lords, of TMC.
You were permitted. There is, I think there is an order because I was party to that proceeding.
Yes,
In the bench I was.
2024, my lords.
R2's reports and legal service. Orally, it was directed on December 6th to serve a copy to me, my lords, so that I can go through it and do.
So we are closing the procedure.
My lord?
Go on monitoring everything. Still we have done.
Sorry, my lord.
So we'll take note of the report of the.
One submission, my lords. My lords. My lords.
Earlier.
My lords.
Based upon this, we have made that order, 9 January 2024.
9/1.
Thereafter.
May I make one submission, my lords?
So we're closing it. We'll dictate the order. Saying that we are satisfied with it.
My lords?
We are closing the.
One submission, my lord. One
Yes.
submission, my lords. My lords, as your lordship knows, the potholes are the recurring issues, my lords. I don't have any issue in closing this matter, my lords, but there should be one permanent grievance cell from the Tumkur Mahanagara Palika, so that whenever the issue arises, people can approach them and it will be addressed properly, my lord. So that every time I cannot approach the court and give a thing, my lord.
Ultimately,
That
it is their lookout, their business, their administration. And you are there to come to the court again.
there should be a specific order in that regard, my lord.
Yes.
Yes, the great.
My lord, this is pertaining to minimum wages. Several writ appeals have been filed and they are all connected with 23/2024, which is listed on 14th, my lord. And
To be listed with.
in this order also,
Along with.
please.
On 14th. 14th is too near, 14th.
May I make one submission, my lord. 63 also.
63 also. To be
Same.
listed with. Same.
In fact, what had happened was 63 was already called. The interim order was granted. By inadvertence, the interim order was not recorded. So I had filed
They
it.
also separate order to be listed with this
Interim order.
same group on 14th.
Much obliged.
Securitization also comes.
Commercial.
Securitization ಬರಲ್ಲ ನಮ್ಗೆ. No, it's the
So to be
Data
placed
base.
as per the register is directed to examine the placement of the in 48 writ appeal and place it before the approved bench as per the roster. It will not come here, please.
But interim order may have to get extended, my lord. There's an interim order not to precipitate.
Interim order shall stand extended till the appeal is listed before the appropriate bench.
Good.
Appellant.
Yes.
Meet the father of the minute, appellant as well as minute, respondent number 5 and 6. Minute got 3 childrens and minute survey number 2, measuring 5 acres, 28 guntas.
Now, how can we look into the validity of gift deed?
Minute gift deed, I'm not questioning gift deed, minute. I'm filing objection not to make kata against this respondent number 5 and 6. Then minute Tashildar make a kata against that order, minute 136 to appeal, minute assistant commissioner stating that minute you have no power, this court have no power to cancel the say.
We have taken the decision. Such things we have to litigate. Please feel
Get your right settled before the civil court. And the learner single has said that the every entry will be subject to such procedure.
No. Minute.
How to change the revenue? Nothing wrong. We'll dismiss it.
No, minute. Some minute, if notice go, you are last minute. Notice go. Some 5 and 6 minute, my sisters.
Take out 86 Karnataka 1059 division bench. Murugarajendra Swamigal versus Special Deputy Commissioner. In all such cases, the only way is to go to the civil court. And full bench has affirmed it later. The Guru Raja versus land draper. Justice Mirde, Rajendra Babu and NDV Bhatt.
In fact, you challenge the gift deed also and it is challenged. It is dismissed. Before
No,
which-
minute, no, minute.
Before
If-
where?
If notice go, you are last minute. If notice go, they are my sisters minute comes to settle the matter. My sisters. 5 and 6, my sisters. One sister.
Based upon registered instrument. That's how ILR 86 says. No option.
Our learned advocate, Mr. So and so, this writ appeal under section 4, under rule 4 of the Karnataka High Court rules is directed against order dated 22nd May 2023, passed by a single judge, dismissing the writ petition. Paragraph. In the writ petition, two prayers were made by the petitioner. First was to set aside order dated 1/7/21 and 18/7/22, passed by respondents number 2, 3, and 4 respectively. It was further prayed to direct respondent 2, Tahsildar, Shikaripura Taluk, to make khata as per the registered will dated 30/12/19 in favor of the petitioner. Paragraph. In respect of the property bearing survey number 2 at measuring 5 acres and 24 guthas, situated at Udugani village, Shikaripura Taluk, Shimoga district, the petitioner claimed absolute ownership. The ownership was claimed not ownership, the respond number 5 and 6, who are the sisters of the petitioner, however got their name mutated in the revenue records on the basis of the gift deed executed by their mother in their favor. Paragraph. The revenue entries made on the basis of the registered gift deed was challenged by the petitioner, which was dismissed. The appeal before response 3, Assistant Commissioner, was also dismissed. Further revision was referred before the Deputy Commissioner, and the same too came to be rejected. Full stop. It is thereafter that the present writ petition came to be filed by the petitioner with the prayers made as above. Essentially, the dispute sought to be raised is on the basis of the validity of the gift deed. The ultimate issue to be decided is whether respondent 5 and 6 have got valid title over the property or not, and whether the petitioner would succeed in his assertion that he is the owner of the property. Paragraph. It is tried principle that TRIT, the disputes regarding property rights cannot be gone into in the writ jurisdiction, and the parties have to take recourse to the civil court. Full stop. Given this settled position of law, learned single judge has rightly dismissed the petition, further observing that if the petitioner were to succeed before the civil court, the revenue authorities are bound to change the revenue entries in the name of the person who is held to be the owner of the property by the civil court. Full stop. No error could be booked in the impugned order of learned single judge. The writ appeal stands meritless. The same is dismissed.
Observation made by this honorable court for dismissal of appeal in an event office objections are not completed in 2 weeks. A date may be given on the day I will come.
Bill number 10.
Yeah, given already. Date is given. First of April.
Malad, small submission, serial number 50, request for adjournment, my lord.
58.
50.
50.
Next week.
Already probably. No.
50.
Why?
Appear for appealant, my lord. Senior is in Delhi. Senior is in Delhi, my lord.
Senior is appearing.
No, senior is in Delhi.
Senior in Delhi.
Next week, my lord.
Oh, next.
Lord, that is connected with writ appeal 210 of 2023, my lord. Section 5A Karnataka Schedule Caste.
Issue notice.
My lord.
Will issue notice.
Yes, ma'am. In this case, I am contesting this.
Please yield space to the counsel who is standing.
I am contesting respondent.
Yes, we have all matters, we have about 18 matters we have already admitted.
But this is in this matters, my lord, it is not granted land, my lord.
No, that's all those things need to be considered, na? In the light of the judgment of apex court in Nekanti, we have already listed all those matters in a pooled way. We have pulled them also, singular orders we have made. Status way.
So it will go together.
Together,
I may be permitted to file objection.
yes.
Much of.
Notice. You will accept the notice?
Yes, my lord, I accept.
Notice. To be heard with. Get the number. Learned additional government advocate, Ms. Nilofar. Accepts the notice. On behalf of which respond, all the respond.
192 perhaps. Assistant Commissioner, Deputy Commissioner.
Judgment is not yet released. The impugned judgment is not there.
Not released.
Not released.
But then, my lord, the petition has been rejected. We had the benefit of an interim order. One of the largest, my lord, hydroelectric projects, 8,000 crores. 5 years, my lord, is the time, my lord, indicated for, my lord, carrying out the work.
Have you sought for dispensation of the order?
Yes, my lord.
Yes, they had benefit of interim order.
Interim order was, your lordship may kindly see page 72. What was the?
Whatever interim order.
Yeah, therefore, between the passing of the judgment and now, my lord, our L1 has been done, financial open has been, bid has been awarded.
Nothing is
therefore-
placed on record.
No, that is
In
why-
fact, my lord, they must, my lord,
will
put it on the website. Nothing is placed on the website also.
We got the order.
Interim order is passed here.
Yes.
We had the benefit of an interim order before the learned single judgment.
The question of,
Single judge.
no, the question, the fact situation when it stood then and now is totally different. In fact, in-
11-3
This
today.
is given on 11.
Today.
Today, my lord,
Today.
today, my lord.
Even ink has not dried.
No, the-
In fact,
In fact, my lord, petition itself is not eligible, my lord, to bid. No, petitioner.
all this, my lord, was,
Petitioner is not eligible, my lord.
all
That-
this was, my lord, to beat, my lord, the code of conduct. What has happened is 8,000 crores, my lord, is the value of the tender, one of the largest, my lord, of hydroelectric projects. 5 years is the time for completion. They have not even, my lord, filed application, my lord, for EC clearance, environment clearance, forest clearance, all that, without which, my lord, they can't even start. And, my lord, the letter of intent becomes effective.
What is the interim plan, sir? Of interim plan.
Letter of intent becomes effective only from the date of. Letter of intent becomes effective only, my lord, from the date FC clearance is given, EC clearance is given, and, my lord, WC clearance. That is forest clearance, environment clearance, and, my lord, page 175. They have not even applied for it.
But now we are disabled from adjudging the validity of the order which you have put in challenge is one thing. That constraint we have. Soon after the order is passed, they have issued this letter of intent.
No, they have issued it today. My lord, please look at, my lord, today.
Today.
They, my lord, we served a copy on them on day before yesterday.
No, what we have done is, my lord.
Right? 7th, my lord, we filed the copy. My lord, we served the copy.
Interim order, copy.
Page
72, my lord.
72, my lord. Please, my lord.
At 73,
So can you read
technical
page-
bid, last sentence. my lord.
So kindly read page from 72 itself, my lord. Your lordship, can I request from 72 itself, my lord?
Then the technical bid is slated to be opened on so and so, the same shall be deferred.
Yes, the technical bid is open, financial bid is open. The question of passing the same interim order does not arise, my lord. Because technical bid is open, financial bid is open, award it has already been granted.
But now we have issued the letter of award.
Award. So therefore, all the steps are for, so the same interim order does not arise, my lord, even if it.
11th is today.
What do you want?
If my lords. Lordships, they were present.
Your lordship, may
Your
kindly-
lordships were kind enough to, my lord, have it today. My lord, were present in the, my lord, court on Friday, Thursday. We moved your lordships were kind enough to, my lord, list it for today. And, my lord, we served a copy. And today, my lord, morning, my lord, if they pass this, that is, my lord, to beat the orders of your lordships court, my lord.
Your lordship, it also.
Therefore, my lord, there's a need to stay this letter of intent, my lord, subject to your lordship's convenience. Anytime, my lord, I am ready to argue. Even now, I am ready to argue. No
Okay,
difficulty. about it.
let him argue, my lord.
No, we should know the
And
order.
that is, my learned friend said he is ready to argue. I am not prohibiting, there's a difference between possibility to argue and
But
ready.
it can't be that, my lord, they make my.
No, your
petition.
lordship, kindly see the letter of intent, last paragraph.
So we.
This letter of award is subject to the writ appeal number so and so. Therefore, my lords, your lordship may decide.
When the present writ appeal comes up for
Please,
consideration before this court, the court does not have the benefit of the order impugned in the appeal. Full stop. All the parties, through their respective learned advocates, are ad idem on this score, awaiting the production of the order before the court. In that view, paragraph, the consideration of the appeal is deferred to the next date. paragraph. Learned advocates for the parties would submit that they would not prefer this court to examine the appeal, which may be rendered infructuous. In that view, the letter of award dated 11/3/24 issued in favor of the awardee shall remain in abeyance.
In fact, no, that is not itself a challenge, my lord.
Till the next
Question,
day.
my lord, in fact,
the next
judgment is, your lordships are saying judgment itself is not available, my lord. Where is that?
Oh, we-
What
we
what
would-
is sought is, my lord, stay of what is passed before the learned single judge.
We would not like to examine infructuous appeal. We'll say that.
No,
Please.
your lordship, the award itself, your lordship may kindly see the award, last sentence of the award, my lord.
The most we can say, learned
Or
advocate
you-
general very vehemently opposed this.
That may not be required. Page 72 may be kindly seen, my lord. May request, page 72 may be kindly seen for a moment, my lord.
It is nobody's fault.
Please, my lord.
It's no fault.
No, not that. Can I read page 72 for a moment, my lord? Your lordship may,
How, it's a right of appeal
please, my lord.
given by the statute.
Please, my
Right?
lord.
First appeal, last appeal also here
Please, my lord.
on law and facts.
Please.
The judgment is not released. Can we put the litigant to the prejudice because the learned judge has yet to release the order?
No, not that, my lord. On interim order, I'm arguing, my lord. Your lordship may kindly turn to page 72 for a moment, my lord. Just kindly turn to page 72 for a moment.
When shall we list the matter?
Please,
This
my
has to be, Mr. Advocate General.
Just 2 minutes, my lord. Just your lordship may read para 72, my lord. The crux of the petition is whether 32 are skipped. Since the petitioner are complete and the instance of learned counsel appearing for the petitioner matter be heard by him, permitting him to participate in the matter, list the matter on third. He refuses to participate in the tender, my lords. This is the case where the petitioner has refused to participate in the tender.
Lord,
And in fact, according to him also, he is
that is
not
also
eligible.
not correct. That is not correct.
No, that is what is recorded, my lord. That is not denied. The learned single judge permits him to participate in the tender. He refuses to participate. In fact, he writes a letter also saying that
270 queries, my lord. They answer, my lord, they don't even answer the queries. 270, every bidder said, please extend it. EP, my lord, EC contractors, my lord, electromechanical contractors said, extend it.
We'll fix it.
Yes, my lord.
Immediately-
Anytime.
Immediately after
Please.
that order comes, we may consider the
Please.
matter itself because
Please.
it appears to be heavy matter.
Please.
Creation of third party interest.
Please read the order. No, starting from beginning. No, write it again. When the present writ appeal comes up for consideration, the court does not have the benefit of the availability of the impugned order dated 6th March 24, passed in the writ petition by learned single judge. In that view, the consideration of the present appeal is required to be deferred to the next date. Paragraph. At this stage, learned senior advocate Mr.
Uday Hallam.
assisted by learned advocate so and so, submitted that the respondent Karnataka Power Corporation Limited is pursuant to the order declared by learned single judge, has already issued letter of award dated 11/3/24, assigning the tender work. Full stop. He submitted that if any further action is permitted at the end of the respondents as well as the awardee of the contract, it will not only precipitate the subject matter, but will also render the appeal virtually infructuous. He submitted that the court would not prefer to examine infructuous appeal. Full stop. the submission is reasonable, paragraph. The court finds that since the writ appeal is at large before the court on its merits, to be examined in the light of the order of judgment and order of law in a single judge, to be awaited to be available. The letter of award deserves to be kept in abeyance. Full stop. Although learned Advocate General, so and so and so, vehemently opposed such a course, the court finds that in the facts and circumstances obtained, it is necessary to keep all further actions pursuant to letter of award dated 11/3/24 in abeyance, and to require the parties to maintain status quo till the next date. Tend over to
After 4 weeks or 4 weeks.
4 weeks.
We have no urgency.
No urgency.
Insofar as interim order, my lords, we'll see
Yeah,
what
we
to do.
can't say 4 weeks. 10 days.
No, my lords, stay has been granted, my lords. We'll file a reply also.
We are not granting stay. This is, you can't say it is a stay.
My lords, we'll file our
Order
objections also.
requiring in the facts and circumstances of the.
Well, if you want 4 weeks, we can write that learned AG wants 4 weeks and therefore granted 4 weeks.
Please.
But if you want,
Ah.
but if you feel it is urgent, then any day, next day, if it comes, move the import. So we'll be able to take it also.
Okay, after 10 days.
Yes, once the order is available. Once the order is available, either of the parties is at liberty to please move the present writ appeal before this
Please.
court. Great, before the court.
Please.
Vijay Madanlal Chaudhary considers this aspect. So particular paragraph is left out, is your.
Because what the learned single judge has said is, learned single judge has quoted the paragraphs which are in my favor, and then said that Vijay Madanlal does not deal with territoriality. However, 269 and 270 say that money laundering is a standalone offense which has nothing to do with the scheduled offense. Those proceedings are independent. Therefore, my lords, even if I have bail for the scheduled offense, I still need to take bail again, which I have. There is a separate investigating machinery. There are separate courts. Two different enactments, my lords, repeatedly had. In fact, your lordship may recall, my lords, last time.
Last week, what is that?
Pavna Debor, I'm carrying that. my lords.
You have
Pavna,
copy of
I
your-
have copy. Relies on Vijay Madanlal. And then, my lords, says that even if a person is not accused in the FIR, he can still be proceeded against under the PMLA Act. You need not be an accused vis-a-vis the scheduled offense. And then there's an example given, para 17, Milords.
This is the latest judgment.
Yes, Milords.
Which is the judgment?
May I read para 17, Milords?
There's one more judgment, now last Friday,
I'm sorry, Milords.
that DK Shivakumar versus Union of India. Latest judgment.
I'm sorry, Milords. I'll need to go back and do my research, Milords. But Pavna Dibur also, Milords, actually helps my cause. And also Manik Bhattacharya.
Do you have, Mr. Kamath, do you have that judgment with you?
Is disposed of on the basis of Pavna Dibur.
That is indeed, my lord, reference was placed on Pavna Dibur, but
Release again.
ಇನ್ನು release ಆಗಿದೆ.
Based on the Pavna Dibur data. But the submission of Union of India is that we have filed a review petition. Once the review petition is disposed of, then we can move.
This very offense, does away with the mens rea, knowingly or unknowingly,
I'm sorry.
directly or indirectly. Offense of
Section
money
3,
laundering,
money laundering definition.
definitely. Very wide, that is what Supreme Court has said, but
Yes.
even otherwise, the element of mens rea is also
It's not
Not
it's
required.
wrong.
if you are part of the process of money laundering, you are.
My lord, if you are in possession or if you are in any way associated with it, if you are connected to it, that is sufficient.
So all judgment stands against you, Mr.
I'm sorry, Milords.
All judgments are against you.
I
An
beg to differ,
interpretation.
Milords. I beg to differ, Milords. Allow me to, Milords, place my submissions. Though, Milords, what your lordship has said is, Milords, it says knowingly, not unknowingly. I'm so sorry to say that. Mens rea is there, Milords. If your lordship sees, Milords, the definition of money laundering under section 3, it has to be knowingly. It may be directly or indirectly. Lordship may kindly have para 7. May I, Milords, have the act for the moment, Milords?
Knowingly or unknowingly, knowingly assess, unknowingly a party.
Not only directly, indirectly, knowingly or unknowingly.
Milords, may we see the act, Milords?
All right, I may not be precise in saying that mens rea is dispensed with, but still it is unknowing.
Still.
It may not be precisely to
Milords,
be
Lordship
correct
may-
that.
Lordship may have
mens rea is
section 3
dispensed
for a
with,
moment.
But still it is.
Lordship may have section 3, Milords.
My lord, before we go into the section 3, Lord, on facts, my lord, there are a couple of aspects that I need to bring to your lordship's notice. My lord, as against the registration of the affair before the Hubli police station, there was a petition filed under 482 on the ground that the Hubli police did not have any territorial jurisdiction.
That's rejected.
Yes, eventually it went up to Honorable Supreme Court. The Supreme Court allowed us to investigate and complete the investigation.
Same party.
Same party, same proceedings. And eventually 482 was dismissed. And 482 was filed on the question of territorial jurisdiction.
Totally incorrect.
Let us.
Totally incorrect.
Let us see.
Please wait for your turn. I'm doing that matter and it's listed tomorrow, incidentally, before the Harvard High Court. Totally incorrect. Here, Milords, what lies at the heart of the matter is that money laundering is a separate, independent, standalone offense. As held by Vijay Madan Lal Chaudhary, they have to deal with that. The learned single judge notes those 2 paragraphs which are in my favor, but does not apply them. Para 269 and para 270, followed in Pavna Dibur, followed Milords in Manik Bhattacharya, followed in Rana Yu, followed in Sharif. Why cause this prejudice by half-baked truths that it has been dismissed, went up to Supreme Court? I was given liberty by the Harvard High Court that you file a fresh petition, which is listed tomorrow, because now charge sheet has been filed. In fact, Milords, in the impugned order, their own submission is recorded. That is factually incorrect. They have said ED cannot initiate any action if FIR is not lodged, contrary to para 290 of Vijay Madan Lal, you yourself are abdicating your powers. And the learned single judge allows that. What is held against me is on the basis of para 467 5A, Roman 5A, which deals with prosecution, not with investigation, a complete misreading of the conclusion in Vijay Madan Lal. I'm sorry, is it too loud? I'm so sorry. Can I reduce the volume? Okay. I'm really sorry on this. Lordship may permit me, I want to argue this on the basis of the scheme. First principles, regardless of whatever be the consequences. And how, the single judge has not gone into any of those. On facts, they have not even disputed my case that every process or activity vis-a-vis the proceeds of crime has happened in Maharashtra, not in Karnataka. Not disputed.
That's all right. But after 1954,
Lordship,
at that famous judgment of 3 judges, Kiran Singh versus Chaman Paswan, 54 Supreme Court, page 347, something I do not remember. There, the territorial jurisdiction was considered to go to root of the matter. But thereafter, there has been a shift in the approach of the apex court to the concept of territorial jurisdiction, where they say territorial jurisdiction does not go to the root of the matter. The issue of territorial jurisdiction can be a matter of grievance where party is put to prejudice because of initiation of proceedings in a court which lacked territorial jurisdiction. That's how there is a shift. If you see the survey of law relating to territorial jurisdiction as enunciated by the apex court of the country, this shift you will see. This shift is also spoken of by two of the judgments of the apex court. Territorial jurisdiction can be a subject matter of grievance where the prejudice is demonstrated, not otherwise.
May I respond to that?
Please.
May I respond? Here, we are dealing with the jurisdiction of a statutory body, namely the Directorate of Enforcement, which is governed, by the PMLA Act.
Not a ground for setting no judgment, conviction, etc. What is your proposition?
My proposition is this.
Yes.
Quite apart from the fact, I'll come to the proposition, that the learned single judge has not non-suited me on the ground that you're not prejudiced. My writ petition has been dismissed, misapplying the ratio of Vijay Madan Lal. Misapplying or misinterpreting the provisions of the Act. My proposition is this, as a statutory body, ED, is every creature of statute. It has to exercise its jurisdiction in accordance with its parent enactment. That's proposition number 1. Article 21 of the Constitution says no person. It applies to everyone, whether you're a citizen or non-citizen. No person shall be deprived of his life or personal liberty except according to the procedure established by law. I need not emphasize, it is not procedure. The procedure also has to be reasonable and everything. It can't be arbitrary, fanciful, or discriminatory after Maneka Gandhi. So the due process clause of the US Constitution has also been read into our Constitution, post Maneka Gandhi. The procedure established by law in this case is the PMLA Act. if you're not exercising your powers in accordance with the PMLA Act, it's an abuse of power. My Article 21 fundamental right is being violated. And with respect, my lords, violation of a fundamental right gives me a cause of action independent of prejudice. Though I will come to prejudice as well, how I am prejudiced. Here, my lords, I am questioning your power to investigate money laundering which has no locus in Karnataka. Otherwise, it will be arbitrary, my lords. Any officer anywhere. Your lordship is right, my lords. There are judgments which say, but they are with respect to the court. At the same time, what does 465 CRPC say? It also says, my lords, like kindly have, my lords, subsection 2. Kindly have 460. Your lordship is absolutely right, my lords. I need to deal with that. So that is with respect to the court. Where, my lords, subsequently later, after the matter or the trial has gone on for some time, then you raise some technical ground vis-a-vis jurisdiction or some other technicality. Let's have 465 for the time being, my lords. And I'll be relying on 2, but I'll read 1 as well.
Did you put forth this contention before the learned single?
Because this question was never put to me, that you're not prejudiced.
No, where have you taken up that contention in your foundational pleadings? Where are the foundational pleadings for that?
For territoriality?
Yeah, no.
Yes, then
You say
lordship.
Subjecting you to a process which is unknown to law
Lordship.
will prejudice you
Lordship.
in Article 21 jurisprudence.
Lordship. Because this question was never raised by them either.
No, you should raise that. You were before the court below.
I was before the court, Milos. I was before the court. I was relying only on Milos, the scope of their powers and under the PMLA Act.
No, that's all right. But the contention which you now want to press into,
Lordship.
that was not the contention that was urged before the learned single
Prejudice
judge.
is something which was never raised by them because the facts are undisputed.
Answer the question.
Lordship.
You will make me to put some more questions. That's not going to help you.
This question was.
We are asking you.
Lordship.
Did you take up this contention? Did you urge this contention before the
let's-
learned single judge? Answer should be binary.
very
I have not.
I did invoke 21, though Milos in a different context. Lordship may just have the ground, Milos. Lordship may just bear with me for a second. Let me just find this thing. Then I should not be making a statement which is not. Milos, page 95 of my writ appeal, and this is the writ petition which I have annexed. Prejudice I have pleaded. And 21 I have pleaded in a different context at page 96. May I read Milos para 61 at page 95? Though this has not been dealt with, Milos. The single judge is silent, whether prejudice caused to me, not caused to me. They have also not made any submission on this. Their reply is also on record. May I read 95, Milos? Para 61. For that, my lord has that. Apart from being in violation of the provisions of CRPC, the ongoing inquiry and the impending trial would gravely prejudice the petitioners who are residents of Ichilkaranji, Maharashtra. The participation in the impugned ED investigation would entail great financial and physical hardship of the petitioners who are residents of Ichilkaranji, Kolhapur, Maharashtra. It may be relevant to mention that all the accused are residents of Maharashtra and their addresses are given in the subject FIR. Not one person is based out of Karnataka. Further, most of the witnesses are residents of Maharashtra. The documents such as bank records, etc., that may have to be summoned during the course of trial will also be in the respective bank branches in Maharashtra. Please kindly have the next ground as well at page 96. For that, the subject investigation has not reached a closure even after more than 4 years from the date of registration of the FIR and crime number 23.
That is elongation violates Article 21.
Pankaj Kumar. Milos, if this question, Milos, may I, Milos, endeavor to answer that. Had they, Milos, put this, how are you prejudiced? Then I would have told the learned single judge, my lord, I have come to you invoking your plenary jurisdiction under 226. Because if 21 gets violated, I don't even have to plead prejudice. And I would have, Milos, placed judgments on that. Here, Milos, lordship may just have the FIR for the time being, Milos, that is the next document. At page 102, my lord may just have this since we are dealing with this volume for the time being. 102, it starts, my lord, please have 103. These are the details of the accused, Milos. Not one person, they're all Maharashtra based. Who is based here? Only the complainant, because he has factories here. Let's read between the lines, Milos.
Your whole case is on territorial jurisdiction only.
Because otherwise I can't be in writ, Milos. I can't, otherwise I'll see quashing only of the FIR, where Milos, now, because the charge sheets have been filed, the learned single judge said that you file a fresh petition. Incidentally, Milos, that is listed tomorrow at Dharwad. But I'm not seeking a quashing or anything with respect to the FIR here.
FIR is registered in the
Hubli.
Hubli.
FIR is there. FIR is in Karnataka. But my
It is
case
raised in Karnataka.
is as in Karnataka. But my case is, Milos, FIR has nothing to do with money laundering. It's a standalone independent offense. Vijay Madan Lal.
Everything took place in Mumbai, Maharashtra.
Let's see that also. Milos.
No.
Let me test that.
We are asking.
200 absolutely right, Milos.
And in FIR, your name figures?
In FIR, my name is there, Milos. Mine and my wife both. She's also been roped in. These are undisputed facts, Milos, and to be fair to them, they did not dispute this even for the learned single judge.
You don't have remedy against the filing of FIR?
No, Milos, I do. I had a stay against an investigation. That matter went up to Supreme Court. By an order, they said, all right, you complete investigation. Once charge sheet is filed, though investigation not yet completed, they are still filing supplementary charge sheets, only cognizance taken, charges also not framed. After almost 6 years, FIR is of 2018. Now, Milos, after 4.5 years in December of 22, ED also steps in. Where do we go, Milos, if the writ courts won't protect us? Here, process is the punishment, Milos. 4.5 years, I'm dealing with the state police and then CID. In December of 22, suddenly they realize there is money laundering also. Has something new happened? Then again, I come here and take bail.
Four 62 of CRPC finally dilutes the concept of territorial jurisdiction by saying
Milos,
that even
I
the order
beg to differ. No.
finding by the court,
Milos,
which is not competent in terms of territorial jurisdiction, which cannot be called in it.
Milos, kindly have subsection 2 as well. Where, Milos, the onus is upon the person who claims prejudice blatantly. It says the court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceedings. I have come immediately to the writ court.
Which section?
Subsection 2, Milos, of 465.
465.
465, Milos. I'll deal with 462 also, Milos. 462 does not deal with investigation. It is inquiry, trial, or other proceedings in the course of which.
Or other proceedings also.
Milos, let's see 156.1 then. How can, Milos, one general provision defeat 156.1 which says that only the officer in charge of a police station where the offense is committed, only he can investigate. 177 says that only the magistrate where the offense is committed can try. These provisions are there, Milos. They're in the residuary category that later, belatedly, you should not. But have 465, Milos. And then I'll make my submissions. Milos, the entire CRPC has to be interpreted harmoniously. May I read subsection 2, Milos? 465 subsection 2.
No, read 465 first.
I'll read one.
Subsection 1.
I'm grateful. Finding or sentence when reversible by reason of error, comma, omission or irregularity. Subject to the provisions herein before contained, no finding, sentence or order passed by a court of competent jurisdiction, court, Milos, shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceeding before or during trial, or in any inquiry or other proceeding under this code, or any error or irregularity in any sanction for the prosecution, unless in the opinion of that court, a failure of justice has in fact been occasioned thereby. This is after the judgment has come, Milos.
That is 462, 465 are independent proceedings.
Lordship.
Kindly see the phraseology of 462.
Lordship.
And see that of 465.
May I, Milos? I follow, Milos, what is troubling your Lordship. May I deal with that? Let's have 465 2, Milos. In determining whether any error, omission or irregularity in any proceedings under this code, or any error or irregularity in any sanction for the prosecution has occasioned a failure of justice, the court shall have regard to the fact
whether the objection could and should have been raised at an earlier stage in the proceedings.
Correct.
Therefore, my lords, if your lordship, I'll read 462 also, my lords.
1 second. The idea of error, irregularity in a sanction,
Lordship,
it is confined to sanction.
lordship.
Subsection 2 of section 465 is sanction specific.
No, my lords. Kindly have
Not
the,
like that.
kindly have the first line. I'm so sorry, my lords. In determining whether any error, omission, or irregularity in any proceeding under this code. And then, my lords, there's disjunctive. That is separate category or any error or irregularity in any sanction.
You are right.
I'm good.
I stand corrected. Come to 1.
1, my lords.
2
Lordship.
speaks of the factors with which one is made up of.
Lordship. Correct.
It is only explanatory of 1,
That's right.
coupled with requirement of demonstrable prejudice.
Correct, my lords.
Nothing beyond that.
So therefore, my lords, let's see this, my lords, from the context of the facts in this case. Yeah.
What is applicable is,
Lordship.
kindly see findings, the title of the section, heading of the section.
That's right.
In India,
Lordship.
heading of sections are also voted in parliament,
Lordship.
unlike in England. In
Lordship.
England, heading of the sections are not law. They are only indicators.
If there is
But
ambiguity,
in
we
our
can look at the
parliamentary
title.
practice,
Lordship is right.
these are also law only. Finding or sentence when reversible by reason of error, omission, or irregularity.
That's correct.
Then we, subject to the provisions hereof contained, no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, revision on account of an error, omission, irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before or during trial, or in any inquiry or other proceedings under this code, or any error or irregularity in any sanction for the prosecution, unless in the opinion of the court a failure of justice in fact has been occasioned thereby. Kindly come to 462. You cannot travel to 465 because we have not yet gone to that level at all.
Lordship's right.
462, as between 462 and 465,
Lordship.
more probably applicable provision is 462. Kindly see that. Proceedings in wrong place.
Lordship.
Your whole case is structured on the premise that proceedings are taking place in Hubli.
No court
when
proceedings.
everything.
No, that's not my case. The proceedings before the special court Bangalore have not even started. I am questioning investigation. Both these sections, my lords, apply with respect to no finding, sentence, or order passed by a court. And 462 says no finding, sentence, or order of any criminal court. They are not a criminal court. They are a statutory body. You have to, my lords, as a creature of statute, you cannot exceed your jurisdiction. That's why we have writs.
How that judgment a learned single judge has relied upon.
May I, my lords?
Vijay Mandal Chaudhary.
Lordship, please. Lordship, may kindly have.
Mandal Chaudhary.
It starts, my lords, at page 38. Because my submission is recorded at page 41 in para 5. And I'll show their submission also that how it is factually incorrect.
Mr. SG, whether any transaction, the whole of the transaction, in the light of section 3 expansive definition, anything happened in Karnataka, just we want to know.
Otherwise, my lord, the state.
No, what is that then? That is important.
As of now, I do not have the charge sheet copy. There are transactions which have taken place in.
Anything which you can link to
Yes.
territory of Karnataka?
There have been transactions which have taken place in Karnataka. The genesis of the criminal activity was in Karnataka. Which is why, my lord, the FIR has now migrated into the stage of a charge sheet.
Where have you taken up such a contention? That they have something to do with Karnataka, Hubli. Where have you taken up that contention?
I'll point it. I'll make a note of that and I'll point.
Just show us.
Before the learned single judge, my lord, we did not file any objection. At the admission stage itself, it was.
All right.
I'm sorry,
Now we
statement
have-
of objections are at page 787.
File again.
This is,
They have filed the statement of
it's
objection.
part of my writ appeal, my lords.
I'm
Page
sorry,
787,
I stand
volume
corrected.
3. You've not annexed one document or anything to show that anything was done in Karnataka, any process or activity which can constitute money laundering. We are dealing with a statutory.
Where have you stated in your objection statement? It was not dismissed in limine. It was after notice you had filed the
Yes,
statement
ma'am.
of
Statement of, I
objection.
stand corrected. Statement of objection was filed.
Page 787. Volume 3, my lords.
Show one paragraph.
Yes.
Where something has happened on a native land.
Lord, in the statement of objection, my stand is that the predicate offense, that is the scheduled offense, was registered before the police at Hubli. Page, para 7, page 789.
No, that may not help you because this is a standalone offense.
But true.
Predicate offense, even you might have registered, that is not sufficient. To register it at Hubli, where are the constituent facts that related to Hubli?
Lord, I am now at the investigative stage.
That's all right.
Yes.
You can't say that.
No, we are asking you,
Lord,
where is the factual ingredient
For that,
for registering the offense at particular place?
Hubli.
Initially, my lord, for the initiation of the proceedings, it was the registration of the scheduled offense in Karnataka.
Correct.
Initially.
How, on what basis? Why not in Goa?
No, because the predicate offense was committed in Karnataka.
Where is that? Take
No,
out, show that.
The Hubli police have registered a FIR, which has culminated into a charge sheet later.
Where is that? Just to show us.
Yes, no, let me show.
102.
Page 102 in the report.
102.
Page 102 in the petition. This FIR, my lord, was challenged before this honorable court in the Dharwad bench by filing a petition under section 482. Initially, there was a stay of the further proceedings. The complainant challenged it before the Honorable Supreme Court, and the Honorable Supreme Court permitted the continuation of the investigation. After the completion of the investigation, the accused have withdrawn the 482 petition before this Honorable Court, before the Dharwad bench. And in the meantime, my lord, the investigation was completed by the state police and a charge sheet has been filed. And a copy of the charge sheet was sent to us, which is when, my lord, we registered our ECIR.
Where the offense is said to have taken place? Said to have been committed?
Within the jurisdiction of Hubli.
Where is that?
Item number 4 at page 102. Kritya nadada sthala. It says Kalburgi Green near Sai Mandir, Vishweshwar Nagar, Hubli. The place where the offense has taken place. That is the generation of the proceeds of crime took place there. This P3 third floor, Lord, is the place where the genesis of the proceeds of crime took place on 1/1/2011. Between the period 1/1/2011 to 25/4/2018. During the period of these 7 years, my lord, the criminal activity is said to have taken place there at Vishweshwar Nagar, Hubli. My lord, a challenge to this on the ground of territorial jurisdiction has been negated, in the sense has not succeeded.
But this is not, these are predicate offenses.
These are predicate offenses, but Lord, these are transactions by which the proceeds of crime are generated. Lord, that forms the same basis for us as well. And my lord, in that Rana Ayub case, my lord, the Honorable Supreme Court has said, if there are disputed facts regarding where it has taken place, their lordships have said it is for the special court to decide.
Matter of investigation also.
The special court should decide, and their lordships say writ court is not the right forum for going into disputed questions of fact. Rana Ayub court, Rana Ayub judgment, my learned friend has produced.
Disputed questions of facts means not every question that is disputed, because always you will dispute. The question is, with reasonable diligence, those questions which have been disputed, court cannot decide, judge them. Only such a disputed, otherwise in every case they will say, this has not happened.
So therefore, let them show one transaction in Karnataka. I have showed 100 transactions in Maharashtra. Please have page 813. You can't just say that it is disputed and
There must be some basis of this.
none whatsoever. None whatsoever. And what my learned friend is saying is that my 482 has been dismissed on the ground of territoriality and therefore it is binding. Kindly have this order.
No, it is withdrawn.
It is withdrawn.
It is withdrawn.
Please see with liberty to challenge the charge sheet. Please, excuse me, ma'am. No, please place the orders. Don't just make statements without placing the orders. Let's have
I
this
am
order.
making statements as per the document.
Yes, let's just see it. Please see the liberty which has been granted to me. That matter is listed tomorrow.
As on today, my lord, there is no petition which is pending.
Of course, it is pending. It is listed tomorrow. 687. Why? How can the ASG make these kind of statements? He's not even there in those proceedings.
It doesn't matter. Come on, what kind of submission are you making? I may not be there, but I have the record before me.
But you said wrong thing. You said the criminal petition is dismissed.
No, I said it is withdrawn. Lord, I stand corrected.
Now you are saying that
Dis-
earlier.
dismissed
you
as
With liberty, my lord.
Now you are
Dismissed
saying,
as withdrawn with liberty.
do not embarrass others also. You did not say that. Now you are saying.
539 other documents, then it would be easy.
Lord, would your lordships kindly have a look at page 513 in the second volume? Page
May I, my lord,
513.
take my submissions first, my lords, otherwise this will be.
Yes. Anyway,
Very well.
we'll come back to you. We'll come back to you. Yes.
Milos, it will take a while, Milos, so I need to kind of place my facts in Milos, because this will entirely turn on Milos, the statutory scheme. There will be Milos, something they will say, but we need to Milos, whether have they been conferred extraterritorial jurisdiction? When Milos, there is an ED in Maharashtra as well. When Milos, there are more than 100 transactions, and incidentally, Milos, this is one case where all the transactions are through bank transactions. RTGS. I've given that list. It's part of the charge sheet. This is not a case where Milos investigation is at an initial stage. CID, Milos, a premier investigating agency of the state which provided you with the charge sheet, had been dealing with this case for 4.5 years before you start ED proceedings against me. You have all that material. And you've attached 12 of my properties all again in Maharashtra. And you're saying we are still investigating. And a writ court has to stay its hands because they're disputed facts. You've already condemned me. 12 of my properties have been attached, Milos, including the house where I live with my family. Because of your lordship's protection, Milos, that attachment has not yet been confirmed, which your lordship granted to me in December of last year. What is it that I'm asking? You show that one process or activity which forms a part of section 3, which defines the offense of money laundering, acquisition, possession, use, concealment. Even 1 rupee out of those crores of rupees does it have a locus in Karnataka? Has even 1 rupee been acquired here? Bank transactions, part of the charge sheet. none of my documents. Lordship may have page 813 minutes because they need to deal with that contention of mine. They've not dealt with it. They've not disputed it before the single judge. Today they are saying, no, these are disputed facts. How can it be disputed? You've not even said anywhere that no, money has actually been procured in Karnataka, or it has been concealed here, or it has been used to buy a property here. And you're saying it is disputed. This was my case before the single judge also. I have, my lords, you've not even filed your objections yet, at least in the writ appeal. Though you don't have to. I'm not saying that you should. But please have page 813, my lords. Because it's important, my lords, that because the facts are very stark. It's not one-off transaction, my lords. There are some 7-8 builders. I'm not even a builder.
You are Rajiv Yadav.
I'm Rajiv Yadav.
So, Mr. Yadav, the very nature of offense
Lordship.
under section 3
Lordship.
is in a way non-stationary offense.
Lordship.
It is in a way running offense
Lordship.
or a traveling offense in terms of transaction, in terms of persons, in terms of the relationship of persons.
Correct.
And also in terms of the territory.
Lordship.
So therefore, territorial jurisdiction, insistence thereof, that the FIR is registered at a particular place.
I bow down.
So that is, how do you react to it?
Section 3, my lords, deals with what your lordship has
Section
said.
3 offense is a non-stationary in the sense,
No,
moving,
it-
moving.
No, no, it says continuing, my lords. I'm sorry. the
Continuing, not moving, we are saying moving.
Absolutely. So therefore, my lords, as a part of that movement, that money should have somehow been traced in Karnataka. Show me that one. Let them show even 1 rupee has either been used here,
But they are,
concealed here, traveled from here.
they are searching that link.
It cannot be, my lords. Therefore, you have already attached my 12 properties. This is not, my lords, a case where they have just registered an ECR and have come running. Here is a case, my lords, from 2018, I'm facing investigation first of the local police, then of the CID. Charge sheet file investigation not yet concluded. That's another factually incorrect statement made by my learned friend. They are still saying we are continuing further. Every few months, my lords, there is a supplementary charge sheet filed. Trial is yet to start. 21 gets violated straight away, my lords. And this is a case, my lords, it's a white collar crime. It is all based on documentary evidence. It's not a case where, my lords, some weapon has to be traced or someone has gone missing or, my lords, the dead body can't be traced. It's all bank transactions.
This is a stage of investigation.
My lords, I'll make my submission. Lordship may deal with them. I'm not for a moment saying, my lords, that I have an open and shut case. But if they don't even dispute any transaction, don't say that even one transaction has happened in Karnataka. Then, my lords, they are answerable to writ court, my lords. You are saying that FIR is registered here. I am saying FIR has nothing to do with PMLA. PMLA proceedings can start even without the FIR. This is what Vijay Madan Lal says. FIR can come later. PMLA only says that you will be prosecuted only after the offense is registered, not investigated. Because this will take time, Milos. I will urge your lordship, Milos. I quite see, Milos, what is bothering your lordship.
This law is made effective
My, and my lord, narcotics, smuggling, coffee. Today, if your lordship see the schedule,
That's a different.
Every offense is,
That's a different
what to do,
idea.
my lord, has been upheld by Vijay Madan Lal, pending review, what to do in Supreme Court?
no, at least in one decision, this court has held. Of course, apex court also. It's very, the objection regions makes it very clear that it's an enactment to give effect to the international convention. That's how it reads.
But within the framework of the 2002
That's-
Act,
That's true.
because it is international, even Consumer Protection Act is international convention. Article 21 is International Convention on Civil and Political Rights. D.D. Basu says that very clearly, Milos. I am not on that at all. It's a very important piece of legislation. But today, Parliament in its wisdom has given you certain powers and a framework within which those powers have to be exercised.
Here on the very concept of the offense,
I'm sorry, Milos.
very concept of the offense.
Lordship.
Incorporated in this act.
Because the definition itself helps me. Definition says it has to be procurement, possession, concealment, use. Please show me out of the more than 100 bank transactions from one city in Maharashtra to another, out of more than 20, 30 properties that have been jointly purchased by the complainant and those builders. I'm not even a builder, I'm not getting into the facts. If even one was purchased.
But they are searching the grapevine.
Milos, whatever it is, you have already attached my properties. What is it today? And Milos, this is not their case before the single judge. I have not been non-suited.
So Mr. Kamath, we want something, some link.
Lordship may give them an opportunity. Your lordship is right. There I
Some
understand.
link and
Let
will
me,
be
let me
created.
get a copy of the charge sheet, my lord, that could have traced us.
He's equally right.
I'll place the
And
copy.
we
of
are
the
also equally strong in confronting.
Milos, we are
Let me
always
secure-
learning from your lordship. Milos. This
Let
is
me secure a copy of the charge sheet, that would,
No, we want you.
No decision, any of these, any high court in the country on this issue.
Milos, I can go. Milos, here is a very interesting case.
No, we are asking.
I'll
Sir,
explain.
there is a
I'll
decision or
explain.
not.
No, Milos.
It's not that there is no decision of any high court, therefore we will not.
I'll
give.
explain.
We will give one.
I'll explain.
That's another.
Milos, here is a case where the complainant, Milos, was acting very clever. Because of his business interests, he himself is a resident of Kolhapur. He knows all the accused are in Maharashtra, Bombay, Kolhapur, Raigad, all these places. They will be pressurized and they will settle with me. Implicate them here. He is the only one who has business interests in Karnataka. Therefore, I said, Milos, we should also sometimes read in between the lines. And now, Milos, Justice Partiwala's judgment says so in the context of 482.
Which is that?
I am carrying it. It says so. I'll place it. I'll place it, Milos. Where it says where there are repeated offenses, the courts, though this is in the context of 482, Milos, I'm again clarifying, I'm not seeking a quashing of FIR. I cannot. I have to be in Dharwad for that and where I am tomorrow. Where, Milos, that if there are these FIRs one after another, the court should not only go by what is written and say, no, we will not quash it because clever drafting. You will cover all the ingredients, engage a lawyer, make sure, cook up a story. Here also the FIR is 60 pages, Milos.
It is probably Gujarat High Court judgment confirmed by the.
I'm sorry, Milos.
It is a Gujarat High Court.
No, no,
judgment.
this is Supreme Court.
No, confirmed by the Supreme Court.
No, no,
As it-
UP, Milos, UP. This is Milos Mahmood or I'll come back, Milos. I'm not carrying it today.
There is no direct judgment of any high court on the issue which you are not.
I'll examine it further, Milos. But may I just say this, Milos? In all fairness, and Milos, let's look at the act. And this is, Milos, may not be taken as my submission, but I'm just, Milos, expressing a view. That ordinarily, the definition is so expansive of money laundering. Ordinarily, there'll be some activity or process where the offense is committed. Here, because this man was very clever, what has he said? Oh, we used to meet here in Hubli. That's not enough. That's not a process or activity.
Now investigation is over and charge sheet is
No,
filed.
no, Milos, nothing is over.
charge,
6
a-
years,
A charge sheet has been filed by.
the investigation pot is kept boiling. Yes, charge sheet filed, supplementary charge sheets filed. They are still investigating, charges also not framed. Only cognizance, cognizance order also I'm challenging Milos before the High Court, before the learned single judge in Dharwad. Investigation not completed. My only, Milos, my intention was not, Milos, of course, my learned senior Milos, is aware of the proceedings and everything, but because there I am Milos, I am against CID and not against ED. So I had said it in that context, that you're not a part of those proceedings. You don't know that, because my learned friend had made a statement that investigation is completed. Even after charge sheet, they are continuing. They may verify. So far, Milos, only 16 volumes have been submitted as charge sheet. So far. Milos, we had to get them photocopied in Bangalore, Milos. Dharwad, we could not even get them photocopied.
So the ball is in your court.
That's what it is, Milos. Here, the process is the punishment,
Let
Milos.
me get a copy of it.
Let Milos writ remedies not be.
What happens is right not to be subjected to undue process of law is his argument. After bank nationalization case, R.C. Cooper, we have borrowed due process of law to Article 21 in substitution of procedure established by law. So what he says is, you cannot subject a citizen to undue process. Though our constitution very consciously did not incorporate that concept, which B.N. Rao went to, Justice Felix Franz Fighter advised him not to put that undue due process of law because it will be highly undue process of law in your country. That's how we adopted on the suggestion of Alladi Krishnaswamy Iyer, procedure established by law. But now it has been equated to due process of law. He says, citizen cannot be subjected to undue process of law. That appears to be pith and substance of. If you show that something, the section 3 definition shares something with Hubli, then perhaps arguably.
On the genesis of the transaction, yes, we'll produce copy of the charge sheet and also get instructions on.
Only this much. Only this much, because your friend is saying they run into volumes. We don't have so much space in the court now. The well of the court is already occupied. Give that relevant material to us.
Very good.
Otherwise, you may subject the citizens. Suppose it happens in Jammu Kashmir. Now we will file a case in Cape Comorin. What should happen to the citizen? So there should be some.
Here, not prima facie, some transactions have been found to have been done in Hubli between the period 2011 to 18.
You show that.
What are those, my lord? Let me get instructions and place the copy of the charge sheet as well.
Would my learned friend also serve a copy, so that we are prepared and we can
Sir,
week before the next year.
Take a copy.
I mean,
If it can be on affidavit.
charge sheet, madam,
No, no,
even
whatever your
otherwise he is
submissions are.
independently entitled for the charge sheet.
No, no, whatever the submissions are,
Rather, he should be having a copy of the charge sheet.
No, no, I have a copy of the charge sheet. But I am saying that you may, whatever you seek to rely on, let there be a
Anything
short objection so
anything
that
beyond
court's
the
time
charge
is
sheet
saved.
or whatever.
So that court's time may
Whatever
be
I am going to
saved.
file, madam, I'll furnish a copy.
Whatever they rely on, because I should not be taken. up to
Relevant
guide.
portion. To link proceeds of predicate offenses to fit into, jump into the vast ocean of your section 3 definition. Very, very comprehensive definition. Of course, we have taken it from that world body.
Yes, there is. That's right.
Yes.
That's right.
In fact, they have reviews at regular intervals. They review the performance of each country. How many convictions have taken place. These are all information which is given to the FATF.
FATF, right.
That will decide how much money to be funded on.
You're enjoying some protection, right?
I'm sorry.
Yes. We have protected you.
Because some protection is there.
Dates
because-
we will mention.
Protection.
All right.
Absolute
I'll
protection is a myth.
Few dates we will
I'll
mention.
leave it. I'll leave it.
Next date you produce those
Yes.
material.
Lord's lordship may indicate that whatever, they need not serve a charge sheet on us, whatever pages or whatever they want to rely on. In all fairness, my lord, as colleagues, as colleagues,
Whatever is fine.
the lordship may give me a week, 10 days after that, or any date.
When we are keeping, 3rd April?
The third of, third of.
Third
April. Third April.
3rd April.
Lord, may I request 2:30, Lord, if possible. 2:30. Interim orders to continue.
3rd April is not Friday.
Third is Wednesday.
Wednesday.
Because interim order to continue.
Then earlier will continue till the next.
At 2:30, mostly.
What is the interim order?
This interim order was, what they have done is,
Not to.
while these proceedings were going on, Milos, and I had pressed for Milos interim protection,
Section 8.
it was denied on that date because you already have bail. So I said, very well, Milos. But it so happened before the next date, they attached 12 of my properties all again in Maharashtra. I'm the only one singled out. There are some 20 odd, me and one more. So Milos, the protection is that even.
That much protection is entitled.
And Milos, may I just say this, Milos, this is.
Given the nuances.
And this is, Milos, a friendship gone bad. The complainant and me, as per the averments in the FIR, were best of friends. We were like family. So therefore, I'm being singled out for special treatment. I'm most grateful.
For 51, PB Ravi Shankar.
Next.
Number 52, the Hemant Raj.
In this matter, we have filed writ appeal against Appeal and single.
Writ appeal is filed.
Yes. Writ appeal number 1567 of 2023.
Learned government advocate, Mr. Mahendra stated that.
Appearing for the petitioner, my lord, the matter is regarding the non-compliance of Annexure A.
Appeal is filed.
Writ appeal is there.
So 53, LM Chidanandaya.
In view of the memo filed by them, the matter, the contempt petition may be disposed of with liberty to challenge the order being passed in the memo, your lordships.
No, they have
Memo
filed,
filed in-
they
memo
have
is being
filed a
filed.
memo. Because this crusher is within 20 kilometer of KRS there. And the complainant has filed a affidavit stating that I am willing to follow the trial blast report.
Lordships,
The lordships may kindly peruse page number 7 of the memo.
lordships, for granting Form C license, your lordships, it's a deeming fiction under section 5(2). For that, the client has written and given an affidavit without his notice. That's a matter to be argued, your lordships. I'm saying I have to challenge the order. The order is
That
very
order,
clear.
they are entitled to challenge that order, na?
Yes, your lordship. Under 5(2), it's a deeming fiction, your lordships.
You want to argue even after he said yes? English version you have not filed,
They have not filed it.
only Kannada. What it says?
Lord, page number 7 may read.
Page
Other
number
than-
5, your lordships, impugned order, sorry.
He's speaking. Please be seated. Please be seated.
Yes.
ಆದ್ದರಿಂದ ನಾನು ಜಿಲ್ಲಾ ಕಲ್ಲುಪುಡಿ ಮಾಡುವ ಘಟಕಗಳ ಲೈಸೆನ್ಸಿಂಗ್ ಮತ್ತು ನಿಯಂತ್ರಣ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ನನ್ನ ಕ್ರಷರ್ ಘಟಕವು KRS ಡ್ಯಾಮಿನಿಂದ 20 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುತ್ತಿರುವುದರಿಂದ ಟ್ರಯಲ್ ಬ್ಲಾಸ್ಟಿಂಗ್ ವರದಿಯಂತೆ ಪ್ರಾಧಿಕಾರವು ಕೈಗೊಳ್ಳಬಹುದಾದ ನಿರ್ಧಾರಕ್ಕೆ ಬದ್ಧನಾಗಿ ಇರುವುದಾಗಿ.
Yes, what is meant by that? You have to tell the court now.
Lord, in this affidavit, he has undertook that, Lord, since the pressure unit is within 20 kilometers from the KRS dam,
Clear, doubts in-
Now,
Within 20 kilometers, they will not run.
Your Lordships, so this is crusher, your Lordships,
keep-
not quarry, your Lordships. This is crusher.
Crusher.
Crusher, your Lordship. Your Lordships have
Crusher
clarified
only
for
that-
crusher.
and
It's-
allied activities, your
Allied
lordship.
under crusher, see, allied activity means it's a adjustum generis in the sense, such activity which will have the effect of blasting itself. That way, how crusher activity is concerned.
Because Lord, if it is allowed, there are chances of illegal quarrying. In order to supply material to this crusher, it is within 20 kilometers of the dam. That is why, Lord, your lordship consciously said crusher, quarrying and allied activities.
Some committee. is there.
Lordship.
Your lordship was pleased to direct on the
Page
last
5, your
week
Lordships.
to conduct this blasting, trial blasting within 4 months.
Condition number 8 of it.
Please.
Lordships, that's the affidavit read. My Lordship, sorry for indulgence. Page 5 may be looked into. Order passed by the district licensing authority. This is my affidavit, the learned government advocate is reading. Page 5 may be kindly looked into, your Lordships. Page 5 of the memo, your Lordships.
The crusher activity.
In view of the undertaking given by the complainant, not stating that, not after the trial blast report, they are ready to abide by the report filed by the trial blast team.
So they have to await report arrival of the report.
That is his statement. It is the statement of the complainant himself.
My license is to expire on 31/3/2024, your Lordships.
Learned single judge, while disposing of the
Division.
writ petition.
Division
the
bench.
Division bench order, your
Division.
Lordships. Division bench.
Coordinate bench.
Yes. It's A.
The coordinate bench while disposing of the writ petition on 16th September 21. Allowed the petition to post the orders giving liberty to the respondents to issue fresh show cause notice to the petitioner in each of the petitions. Time, full stop, time of 15 days was also granted to file reply, comma, whereafter the competent authority under the Karnataka Regulation of Stone Crushers Act 2011 was permitted to take a decision, final decision in the matter after giving opportunity of hearing to the petitioner. While the aforesaid directions for the subject matter of the contempt proceedings from a learned government pleader, Mr. Mahendra, invited attention of the court to the filing of the memo dated 5/2/24, which reads as under, and quote the memo, full stop. The memo indicates that the proceedings dated 14/2/22 came to be undertaken, and the order is passed by the Chairman and Deputy Commissioner of the District Stone Crushers Licensing and Regulation Authority, Mandya District. Copy of the order is also produced. Full stop. The above proceedings and the order paragraph mark compliance of the directions of the coordinated bench. In that view, the contempt proceedings are required to be closed. According to it is closed. At this stage, paragraph, learned advocate Miss so and so submitted that the liberty may be reserved for the
Complainant to challenge the order.
challenge the order in question.
Order dated 14/2/2020.
It goes without saying that the order gives fresh cause of action to the complainant. However, the court does not express any opinion or merits
Much obliged.
on the proposed challenge. These proceedings are accordingly disposed of.
54, the Nandita. Appear for the appellant in the.
Serial number 55, my lord.
Yeah, what?
There is an application for condonation of delay of 13 days.
On merits, what is?
Pardon?
13 days.
13 days delay.
No liberty should have been given to file the representation.
No, not representation. I am aggrieved by the para 10 of that order.
That will
where
continue, that
Continue
continues.
the interim order granted in another matter. In this matter, there was an order that his pension was stopped. So that order was stayed. So we have restored the statutory pension. Now, as per the order passed in 8767, which I have produced at page 190, the court has directed that to restore the old pension retrospectively from March 2020. Now, as per the Supreme Court final order, this person is not eligible because he has retired prior to 1st September 2014. But because of this order now, we have to pay.
so and so, notice to the respondents.
Sought for stay of that order if they file a contempt regarding the recovery.
No, unless delay is condoned.
Oh,
Cannot leave.
Returnable on 3rd April. Government bidder. Will accept, government is there. Mr. Mahendra, you are there in this matter.
against Union of India, no relief is sought, only against the respondents 1 and 2.
So,
I have mentioned it in my.
so there.
Number 55. Chandra SN.
Serial number 55. Kindly permit me to appear online, Malad. But here is the writ appeal has been filed challenging the order passed by Malad Learned Single Judge on 12/10/2023, which your lordship will find in page 13. It looks to be a very simple order, Malad, wherein following the judgment passed in Malad WP 12954 of 2021, this repetition was also disposed of. But there are two things, Malad, which were not considered by the Learned Single Judge. Is that the petitioner before the writ court is guilty of not disclosing that there was already an order passed by the authorities fixing the tax.
That order you have not challenged, WP 12954 of 2021.
Well, that is an order where the management has challenged the provisions of section 152, clause 1, subclause B of the BPMP Act, wherein there was no exemption given to the education institutions from paying the tax, building tax. When the matter was pending before the writ court, the government had issued a notification bringing in an amendment, that is on 13/3/2023, granting the exemption. In view of that, that writ petition was disposed of. No doubt the petitioner herein, the first respondent herein is also the education institution. Two aspects were not considered is that already there was an order.
Where is this
You have not produced that order.
order?
Please, Malad.
The order pursuant to which relief has been granted to the respondent petitioners, WP 12954 of 21.
Yes.
That order.
What I am saying is that order is not applicable to this case because
to examine whether it is applicable or not.
My lord, I have a copy. My lord.
You have that copy with you.
Portion of this.
Lord,
This order appears to be.
Heard your senior learned so and so for the for the appellant or none and the additional government education snail of the field deserves to be admitted. Same may be listed for final consideration in the week beginning from the first week of May 2024.
Yeah, already education.
First week of, last week of May.
Number 56. Mr. Badrinath.
Land has been granted on 1945. Where the revenue entry has been transferred to the name of appellant's father. The suo motu proceedings has been initiated against the respondent by the appellant in the year 2008. 2008, where the Special Deputy Commissioner held that the proceedings has to be dropped. Again, based on the very same letter, in 2018, same proceedings has been initiated.
Whether in the original records, your father was granted land,
Yes, with granted land.
but original records said something else.
But may kindly look into first time where the Deputy Commissioners passed the order in page number 183.
No, that itself is being faltered by the learned single judge.
Madam,
He
that is-
says, Deputy Commissioner, without looking into the original records reflected no grant at all.
May kindly look into the kind of Deputy Commissioner order, first order, in page number 191.
So Learned Singhal just said that the original record indicates that.
Indicate that he is not the
Where the original record is there.
Otherwise.
But next, the secondary document. Annexure F1, page number 188. Operative portion of the order is at 191.
Correct.
Now, this order has been reached finality.
That way, no finality, where this order is made under which section?
136(3).
136, read 136, only for the purpose of the revenue generation, nothing beyond that, no title under 136(2), 136(3), 128, 129, no title.
No.
Can't go by that.
Grant certificate is not there with me. They had issued a endorsement to me. Where the secondary Sagoli chit is there, it can be looked into me.
Where is the original records have been looked into by the learned single judge. Then he said, the findings recorded by the Deputy Commissioner are absolutely without reference to original records at all. And it is only for the limited purpose of revenue. 136(2), what is that? What the apex court said, this court also has.
But revenue proceedings has to be initiated within a reasonable time. With the very same proceedings has been initiated in 2008 as well as the 2018 also same proceeding. May kindly look into file 191. Shall I read?
What will assuming that what you say is true. Still, all government lands.
Even if I'll produce the grant certificate before then.
You could have produced it before the learned single judge if you had one. Since you did not have, original records were looked into, then learned single judge said, this land is not granted.
I had produced the Sagoli chit extract before the learned single judgment.
Huh?
Before the learned single judge, I had produced the Sagoli chit. Sagoli chit it is there.
Sagoli chit is not sufficient. The division bench of this court said, to prove the grant, you have to produce the grant certificate. In the alternative, you have to show the entry in the original grant register, saying that this land has been granted, given in Telecast to XYZ. Otherwise, going by Sagoli chit will be dangerous. No property of the state will be retained.
With me, the grant has been made to another 8 persons has been granted to me. May kindly look into Annexure B, it is there. But I'll produce the grant certificate itself, which I think.
18th.
I'll produce.
18th.
Yes. The interim order has to be.
What interim?
Interim order, granted? Yes.
Yes. original certificate of grant indicating the title of the property. Full stop. In view of this request, tender over to 18th of March, interim order granted by order dated 23/1/24 shall continue to operate till the next deployment.
Number 57, appeal by government.
Lord, I appear for the appellant. My lord, there's a delay of 693 days, my lord.
693 days.
The order was passed on 12th December 2019, and because of the COVID, my lord, the appeal could not be filed.
Everything has been concluded in WPA 5054 of 74 of 1997.
Yes, my lord.
Grant was set aside by Assistant Commissioner.
My
It
lord,
was restored by the Deputy Commissioner.
Yes.
Matter went in appeal to the Karnataka Appellate Tribunal.
Yes.
Appellate Tribunal upheld the order of the Deputy Commissioner. That was challenged in this writ petition. Writ petition came to be dismissed. This was in 1999, 16 July 1999.
My lord is right. Thereafter, my lord, again the deputy commissioner invoking section 25, my lord, annexure F, page 49, passes an order saying that the grant is not genuine.
No,
Right.
section 25 is, how section 25 inherent powers are available to him? No, covered by judgment. Section 25 is like 151 of CPC. If some proceeding is pending, only then it will use that. If proceedings are concluded, 25 is not in.
My lord was presiding over this bench along with my lord justice, the then chief justice.
Any fraud or anything has happened?
No,
No fraud.
no, same, I have only one copy. ಇಲ್ಲ, ಅದು ಕೊಡು, ಅದು ಕೊಡು.
This goes against you.
Yes, my lord. I didn't want to. Both the orders. Passed by my lord. Lord, there is another order passed by the division bench of this honorable court.
Section 25.
Power of review has to be expressed. This is, you can't invoke this. So this, what is this appeal?
My lord, I leave it to my lord, my lord. It should not be said that I've conceded,
No.
but I brought it to the notice.
Not following the-
I give. The Assistant Commissioner had cancelled the grant on the ground that the grant was not vouched by the records. First, the matter was taken in appeal before the Deputy Commissioner, who, having set aside order of the Assistant Commissioner, had restored the grant. First, The deputy commissioner's order was put in challenge before the KAT in appeal number so and so, and the same was negatived by the tribunal. First off, matter did not rest here. First, further challenge was laid to the order of the KAT in WP number so and so, which came to be dismissed on 19/7/1999. First, in view of all these things, learned judge, single judge has opined that the deputy commissioner could not have invoked section 25 of the Karnataka Land Revenue Act 1964, which approximates to section 151 of CPC 1808. First, in the absence of power to review being specifically granted by a statute, there cannot be review of the orders, has been settled by the apex court more than 50 years ago. First, in view of the above, the writ appeal being devoid of merits is liable to be and accordingly dismissed. Rejected in limine.
Number 58. Umapati, yes.
I am for the petition, the prayer in this petition, the fourth respondent is holding the post of Director of Prosecution without the concurrence of the Honorable CJ, Chief Justice, and also against the violation of the 25A of the CRPC.
Warrant is sought, my lord. Lord had on an earlier occasion considered and passed an order on 1st of March 2024.
What GK Govindarao State University of Mysore said.
Yes, ma'am.
This is writ petition directly.
Because forum to actually lies even before the bench itself.
This is PI?
Yes, ma'am.
Yes, ma'am.
Section 25A of the CRPC is very clear. A Director of Prosecution should be appointed with the concurrence of the Honorable Chief Justice of the respective court, and also those who should have completed minimum 2 years as a Deputy Director of Prosecution. There cannot be any direct prosecution, any outside minister, because it is an independent organization. It will affect the very administration of the justice. A judicial officer who has been working for the last 1995, now he is heading the Director of Prosecution. There cannot be any this one.
What are the rules of appointment?
But CNR rules clearly says that the person Director of Prosecution should be appointed by promotion by selection from the cadre of the Deputy Director of Prosecution with the concurrence of the Honorable Chief Justice of the High Court of Karnataka. That is the norms.
Which is that rule?
CNR rules, madam.
CNR rules.
Yes, madam. Dated 26/6/2014, madam.
Cadre is?
Deputy Director, madam.
Deputy Director.
Yes, madam.
Now,
and if there are no Deputy Director with sufficient experience, at least any person who has put in the service of not less than 1 year may be considered for promotion. It is only by promotion, madam. There is no director. And also, madam, so CRP sections 25A clearly says.
My lord, my statement is also ready.
25A, madam. Director of Prosecution. The state government may establish a Director of Prosecution consisting of a Director of Prosecution and as many Deputy Director of Prosecution as it thinks fit. Second, a person shall be eligible to be appointed as a Director of Prosecution or a Deputy Director of Prosecution only if he has been in practice as an advocate for not less than 10 years. And such appointment shall be made with the concurrence of the Chief Justice of the High Court. But here, since the 2019 August, he has been holding the post continuously by extension order of the government. Annexure A to E may be kindly be pursued, Mala.
I have a copy to give it to them. My lord could have this next week, my lord.
Next week, 1 minute matter. Timing wasted in that. What is the ground you have taken defense? He has taken up two contentions. Number one, from the feeder cadre, promotion has to take place. You cannot appoint anybody. He should have minimum number of years of service. 3, with the concurrence of the Chief Justice. Whether that has happened in this case?
No, my lord may take from paragraph 4, my lord.
Paragraph 4.
Yes, of my statement of.
Four says the legal position.
Yes, my lord, there was a challenge with regard to the seniority list, because of which, my lord, the appointment could not be made. My lord, again, there is this thing that is pending, and now the list is being revised. The moment, my lord, the seniority list is out, we will appoint a director.
No, why did you appoint without concurrence of the Chief Justice? What is the object of
My
section
lord, there was
26A?
My lord, there was no candidate available for the post of deputy director.
Kind of answers. The Directorate of Prosecution
Yes,
is an institution by itself.
yes.
In that
my lord.
Veerappan judgment, Supreme Court, Khader, Abdul Hamid versus State of Karnataka. Therefore, the Law Commission suggested there should be concurrence of Honorable Chief Justice. You can't make without the concurrence of the Chief Justice. Admittedly, you have not done it. The litigation is being fought on the service law side is different. How you could make appointment without the concurrence of the Chief Justice? But challenges to the appointment
Lord,
of
could I make
respondent to the post of Director of Public Prosecution in terms of as provided under section 26 capital A of the Criminal Procedure Code 1973, coupled with the C&R rules, so and so. First, learned counsel for the petitioner vehemently argues that the appointment of Director of Public Prosecution is an institution by itself, and it has its own status in view of several independent functions to be discharged by him under the provisions of CRPC, including withdrawal of accused from prosecution as provided under section 321. First, learned counsel secondly argues that the incumbent respondent does not possess the requisite qualification. And thirdly, he submits that no appointment to the post in question could be done without the sanction or without the concurrence of the Chief Justice of the High Court concerned.
Lord,
First,
could I just
learned.
My lord, could I just
AG.
interfere 1 minute?
Huh?
My lord, could I just intervene 1 minute? My lord, he is an in-charge director, and I have made that clear in paragraph 3 of my statement of objections, my lord. My lord may take that into consideration. It's not a full-fledged, my lord, director who has been appointed.
How long he has been working?
My lord, he has been appointed since 1/8/2019.
19 August.
Last
No,
days.
no, my lord, no,
Eugene-
my lord may, my lord,
Beyond this 1 year.
4.5
The
years.
rule
my lord,
32.
I have, my lord, in my.
I'll say that also. But learned EG appearing for the respondent opposes the petition, contending that there were service law disputes concerning the seniority of deputy directors of prosecution and semicolon. No candidate was available having a requisite qualification, and that the post in question could not be kept in abeyance, regard being had to statutory functions attached to the same to be discharged in time. Semicolon. Lastly, the contention, the present incumbent has been placed on independent charge of the office in charge of the office in question under Rule 32 of KCA. Is it under 32?
my lord, we just issued that order.
Presumably under Rule 32 of KCSR. 7. The question of complying with the requisites prescribed under Section 26 capital A of 1976-73 code would arise only where a substantive appointment has been made and not otherwise. First, so contending, she seeks dismissal of the writ petition. Having heard, do you want to say anything?
We did not, a formal party.
Learned
Registrar General.
Who are you?
Registrar General of this.
Having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter in as much as the present incumbent has been placed in so-called in-charge arrangement, presumably under Rule 32 of KCSR, and such an, since 2019, semicolon.
August.
The government orders under Rule 32 specifically say an in-charge arrangement cannot continue beyond 1 year in any circumstance, semicolon. Thirdly, Rule 32 itself says no person who is not eligible to be promoted to the next cadre can be placed in charge or independent charge of the post in question. Second, lastly, the appointment to the post in question cannot be done whether be it on substantive basis or by in charge stroke independent charge basis, sans sanction of the Chief Justice. First off, had it been for a short period to to ensure that the functions of the office are not stalled, we would have understood the contention that an independent in-charge arrangement would not attract the rigors of Section 26 capital A. First off, as already stated, we repeat that this appointment has been going on since 2019 and it is not a happy thing to happen. First, next part. In view of the above, this writ petition is allowed. Writ of certiorari quo warranto issues, removing the respondent, fourth respondent from the office of the Director of Public Prosecution. Forthwith, first, a further direction issues to the state to take all steps to make regular appointment to the post in question after following the procedure prescribed under Section 26 capital A, and wisdom may be drawn from the decision of the apex court in Chandrasekhar Ayya versus State of Karnataka.
My lord, could I just prevail on my lord?
CRP section.
Without booking.
Without booking any deal.
Without booking any deal.
Section
Just appointment
25A,
to-
madam, it's
without
not
booking
26A, 25A, yes.
25.
Yes, Pachala. Deep
Give that judgment, Justice Chandrasekhar Ayya's judgment.
Please, ma'am, look.
Where the consent of the concurrence of the Honorable Chief Justice was not taken, it has been struck down by the apex court.
Much of
Yes.
My lord, a reference to Rule 68 of the Karnataka Civil Services.
KCSR 68. 68 is then you will be worse case. I'll work on Rule 68. 68. This a bench of this court has taken the view that an in-charge, an officer placed on in-charge basis or independent charge basis is not entitled to exercise statutory functions. Why Basavaraj Dhotra versus Karnataka Land Army Corporation, ILR 2004-6, Karnataka, so and so signs. And Kodi, ILR, we have followed that one, na? Cost collecting
Something fundamentally wrong in this. Yes.
With your lordship's kind leave, my lords, there's a delay of 23 days in filing the appeal.
Yes.
My lords, a preliminary notification, before that, a notification declaring the areas, industrial areas issued on 38/2021. My lords.
It's under
The KID Act, my lords.
KID.
Karnataka Industrial Area.
1966 Act.
Please. My lords, pursuant to that, the final notification itself is not issued.
Not issued.
Not issued. During that time, my lords, the petitioner lays a challenge to the preliminary notification itself. Based on a premise, my lords, that there is a circular which is primarily for internal governance in as much as issuance of preliminary and final notifications are concerned.
and whether an area is to be included in the said notifications or no, and the procedure to be adopted.
That is a 3/3/2007 circular.
That is now that has been remodeled, my lords, in the 2013 circular, which I have produced at page number 286, my lords may please have. 286, my lords will find the 2013, which is now revisited. The 3/3/2007 one is revisited.
What it says?
My lords, it says that there has to be a, I'll just read, my lords, the Kannada version. Prathamika Adhisuchane
What it says, say it in English.
Before issuance of the notification as such, there should be a survey. And as per that survey, whether this land is required or no, there has to be an application of mine by the SLAO before he proposes. Now, this is in the backdrop of the fact that a lot of lands are without application of mine are notified for acquisition, and at a later juncture, we have to delete them. Now, my lords, only when the preliminary notification was issued, still the final was not issued, still at the stage when he was to file objections as such. It is our case, my lords, before the learned single judge.
That circular is issued under which section of which law? Has it got any statutory flavor?
That's it. That is our point before the learned single judge, my lords. We have taken up a contention that it has no statutory flavor and it has more of an internal governance because it is issued by the Principal Secretary's Office of Commerce and Industries, which issues the notifications as such. And the SLAO is a delegatee of the state under the Rule 21 of the Karnataka Industrial Area Development Rules. Now, my lords, at this juncture, we say that even assuming there is no application of mine, because incidentally, I have to fairly concede, my lords, that an endorsement was issued by the office of the SLAO, that we have not done the survey that was contemplated by the circular as such. That circular was now produced by them in the challenge. Our contention, my lords, is he could have taken up all these contentions when in the objection stage. It should not be annulled at this stage was our submission.
It is covered in 66. Scheme. They will have an opportunity. Justice, 2009 judgment, ಯಾವ್ದದು? Which considered the entire scheme of the 1966 Act. Justice Manjula Challur and 2000, Justice Indrakala, somebody, division bench said it went to apex court. This. Anyway, what is the sanctity attached to the circular?
My lords, sir, this honorable court, my lords, 2 division bench judgments, my lord, have held that the circular is binding on the KIDB, and the circular, my lords, is issued in pursuance of the government has a power in order to remove any difficulties under section 48. They have the power to issue circular.
Circular?
Issue any direction, issue any direction.
No, that's
Section
interpreted.
48. My lords, there are 2 judgments, my lord. I'll just pass if I can just pass the 2 judgments, my lords, where my lords have considered this issue.
That non-compliance of circular will render the notification vulnerable for challenge.
It has been set aside. Yes, on non-compliance of circular, my lords, it's been set aside because the my lords, they hold that the SLAO has a duty this before issuance of 28(1) notification. May I just pass the 2 judgments?
1 second. You were reading that the removal of difficulty clause, no?
Yes, my lord, section 48, my lords.
By notification, is it notified?
It's a circular, my lords. It's a sutor.
Not notified. It's not a notification at all.
Not, it's a circular. It's a circular. It is a circular issued by the Commerce Department, which is binding on the KID.
No, where is that? How? Whether this aspect is considered by the division?
Even the null and single judge relies on that judgment, my lords, in the
The earlier judgment, no, the earlier judgment. Page number. Page number. Page 8.
48 has been referred to.
I'm sorry.
Section
No, no.
48 has.
Writ Appeal 461 of 2016.
Page 13, Manoj, may I just request Manoj to take page 13. Paragraph 11, page 13. Second judgment in. Page 13, I'm sorry. Page number, page 13, paragraph number 11.
You are the petitioner.
I was the petitioner, Manoj, before that.
Judgments. Give that judgment.
That judgment is also there, Manoj, in the compilation. Serial number 3, can I just back? Manoj, I'll just show the judgment. Go ahead. Let's see, page number 15, Manoj.
Please.
Page number 15, it's the third judgment in my compilation. But then the same point, my lords have also considered in another judgment, which is at serial number 1.
In your compilation?
Yes.
Yes.
Serial number 15 is the first, then my lords sitting have followed in serial number 1. Serial number 1 is the first.
2 years.
2 years. My friend was also on the other side. I was
On the very first day, I'm experiencing the vastness of my.
yes, my lord. Without saying.
Deeply obliged, deeply obliged.
Good vast spread of my brother.
Yes, yes.
Deeply obliged.
Yes.
Thank you.
Day after 2.
My lords, Madam Lords, fresh matter. Notice may be ordered, my lords, there is a delay, my lords.
Which
It
one?
will come, please.
May I make a request, please? Serial number 61 may be taken up next week.
All right, next week.
My lords, in serial number 69, I may be allowed to withdraw the petition. my lords.
Withdraw.
Yes, my lords.
Learned Advocate Ravindra Gajan Kole seeks permission upon instructions of the, what is this RP? Review petition upon the instructions of the
Please, my lords.
petitioner. In that regard, he submits the memo of withdrawal signed by him, prepared upon the instructions of the, upon instructions, the review application is dismissed as withdrawn.